We are so glad to have you this morning. My name is Zubeda Namgenyi, and I'm the CEO of the Muslim Arbitration and Mediation Center, Uganda, and I'll be your moderator this morning. I'm beyond thrilled because we managed to put together this, and His Lordship Justice Mubiru is already here. I know most of you are coming in for him. Mr. Chirunda is already there also. He's logging in from South Africa, but he's already ready to share golden nuggets. Miss Olivia Chalimpa is already here. So let's all get ready and excited to learn more about commercial drafting and how we can improve our craft as lawyers. My name is Zubeda Namgenyi, as already introduced, and I would implore you to also write your names in the chat box as you log in, and I'll be sure to spotlight some of you, especially the first ones. Tell us where you are, what's your name, and the organization you're coming from. And that would help us connect properly. This legal writing masterclass is work that we put together as the Uganda Law Society and the Muslim Arbitration and Mediation Center, Uganda. And it's a product of our first legal writing masterclass that took place on 22nd August, which revealed that there was serious need for us to learn more. Members were they requested that we have niche-based legal writing conversations, and the first being the commercial edition. So as we go along, we would like for you to suggest different niches where you would like for us to organize legal writing masterclasses, because we have realized the need is there. And you could also suggest the speakers that you think would ably deliver on the different niche mediation masterclasses. We all know that legal writing in Uganda is not where it should be. And the judges are tired, clients are confused, lawyers are also frustrated with some judgments. And so we need to take it upon ourselves to do more to improve writing, as it is central to our craft. It's not a side job, it is a main tool in our work, and so we need to do more. That's why we argue and persuade each one of you to be proactive, get your pens, be ready to learn, and also share your comments in the chat box. Today, I'm so excited because Justice Mubiru, I'm such a big fan. Actually, when we were organizing yesterday, Doreen, the one in charge of members' affairs, was like, is he coming? Is he really coming in person? When I said yes, she was like, please tell him we are such big fans. And I'm sure many people on the call are such big fans. We've interacted with your work. And the tagline for this legal writing masterclass is, let your writing speak louder than your titles. And I think no one's work has spoken louder than their titles as yours has. We are so glad to have you in our midst. We are so happy to have you as a law society, as a country. You have contributed immensely to the growth of jurisprudence, and we hope to learn from you today. And I would like to highlight the objectives of this masterclass, and that is to raise awareness of the critical role of commercial writing, to equip lawyers with practical tools for drafting precise and enforceable commercial documents, to bridge the gap between the training at LDC and the real demands of practice, to explore the role of AI in drafting, its potential, its limitations, and ethical considerations, and to promote a culture of clarity, conciseness, and credibility. Our first speaker is going to be Justice Mubiru, and Justice Mubiru he's a judge of the High Court of Uganda. He joined the High Court in 2016. He has previously served as a resident judge of Arua and Gulu High Court circuits, head of commercial division, and is currently the senior resident judge of Mukono High Court. Justice Mubiru began his professional career in 1992 as a legal assistant with Kawanga and Kasule Advocates, a private law firm in Kampala, where he subsequently became a partner. In 2003, he was appointed as assistant lecturer at the Law Development Center in Kampala. He subsequently became a senior lecturer and head of research of Department of Research, Law Reform and Publications, and later the head of the Bacchus. He holds an LLB from Makerere University, a diploma in legal practice from the Law Development Center, an LLM from Utrecht University, I hope I haven't murdered that one, with a focus on international human rights and criminal justice. Now, my experience with Justice Mubiru, he doesn't know, but when I saw, he doesn't know, I guess, the sort of impact he has had on us as students at the Law Development Center and as practitioners. When we were at LDC, and I was at LDC in 2011, we quickly realized that Justice Mubiru was a different facilitator. His way of doing things was so different. And so we would follow him around. Like every time we would have the week's list, we would see which firms he's going to, and we would follow him throughout the whole week. And of course, that came with the risk of missing out on signing for your attendance, but yeah, it didn't matter. Now, as a judge, his judgments have actually influenced a lot of decisions in this country, and I speak from my experience when I was working at the Supreme Court of Uganda as a legal assistant. You would be researching about a topic, and when you would find a judgment written by Justice Mubiru, he basically had covered all the bases. You would basically be like, it is done. Like, so that is why your judgments, even as a High Court judge, have been quoted in Supreme Court decisions. And Your Lordship, we are so grateful for your contribution. I would like for the members on call and Madame Olivia, let's put our hands together for Justice Mubiru. You are most welcome, Your Lordship, and I would like to allow you a few minutes to say something before I can introduce the other panelists and then delve into the program. Thank you, Your Lordship.
Thank you very much for the very warm reception and a very pleasant introduction. I'm honored and privileged to be invited this morning to participate in this discussion. I hope we shall have a very fruitful engagement. I expect to have a very fruitful interaction from all of you. I'm glad that I'm introduced by my former student, and I'm flattered by the very warm words of encouragement and appreciation of my work. Thank you so much. You are the reason we keep going on.
Thank you very much, Your Lordship. Our next panelist is Miss Olivia Chalimpa, and she is an advocate of the High Court of Uganda with over 18 years of legal practice, specializing in dispute resolution. As the head of dispute resolution of the dispute resolution department at LegalMark Advocates, Olivia offers strategic legal advice across various domains, including corporate, commercial, litigation, corporate governance, ESG, advisory, and board training. Her areas of expertise also encompass leadership, commercial arbitration, employment law, mediation, litigation, human capital management, securities enforcement, and insolvency. With extensive experience as an arbitrator, Ms. Olivia is a seasoned dispute resolution practitioner. She has provided invaluable advisory and corporate governance training, as well as dispute resolution services to a diverse array of clients, including financial institutions, statutory corporations, non-government organizations, private entities, and government agencies. Ms. Olivia's commitment to leadership and education is reflected in her numerous roles, including having served as a professional advisor and lecturer at the Law Development Center. She also heads training and accreditation at the International Center of Arbitration and Mediation, and is a trainer for Justice Advocacy Africa and Justice Advocacy Uganda. As a founding member and honorary treasurer of the Chartered Institute of Arbitrators, Uganda chapter, Olivia has significantly contributed to the growth of arbitration in Uganda. Her other roles include her membership on the disciplinary committee of the Architects Registration Board and serving as a chairperson emeritus of the Uganda Law Society Arbitration Cluster. She holds an LLM in International Dispute Resolution, a certificate in International Commercial Arbitration from the Chartered Institute of Arbitrators, and a special diploma in trial advocacy, and a postgraduate diploma in legal practice from the Law Development Center, and a Bachelor of Laws. Please, let's all put our hands together, our virtual hands, if you're online, to welcome Ms. Olivia Chalimpa. And what I haven't said also is that when I was starting out in the ADR space, I remember coming to your office and you guiding me through the process. Thank you very much. The next speaker is Mr. Chirunda, who is joining us virtually. Mr. Robert Chirunda is the founding and managing partner of Chirunda and Company Advocates, with almost 2 decades of experience in providing advisory services. Robert counsels domestic and international clients on complex multi-sectoral transactions, offering pragmatic, commercially focused, and astute legal advice. He has served as director of various companies, including Finance Trust Bank. Robert has also a wealth of experience in advising clients in public and private sectors and on dynamic evolving landscape of emerging technologies. He was part of the team that developed the Uganda's national 4IR strategy, and is the leading he's leading the team conducting legal and policy audit on the science, technology, and innovation sector. He is also recognized as an intellectual property agent of the African Industrial Property Organization. In addition, Mr. Robert has a wealth of experience in dispute resolution. He is an advocate of the High Court of Uganda and an accredited mediator. He's also a member of the Permanent Court of Arbitration. That is his recent accolade, and a member of the Chartered Institute of Arbitrators in London. He also presently serves as co-head of the arbitration law cluster with the Law Society, and has served as counsel and arbitrator in several multi-million-dollar disputes and handled several complex commercial disputes. Mr. Robert Chirunda also teaches at the Makerere Law School, and he's also the convener of the Center for Law and Emerging Technologies. He holds a master's degree in law, science, and technology from Stanford Law School, a master's of law in trade and investment from the University of Western Cape, an honors degree from Makerere University, a postgraduate diploma in legal practice from Law Development Center, and has completed his studies for the award of Doctor of Philosophy in Commercial Law from the University of Cape Town. Let's all join our hands physically and virtually for Mr. Chironda. Now you're welcome, Mr. Chironda. Can you hear us?
Yes, I can hear you. Can you hear me?
Can we?
I was muted just now, but I hope you can hear me.
Yes, we can hear you. Thank you for joining us.
Sure.
Without wasting time, I would like for us to delve into the keynote that is being presented by Justice Mubiru. And the terms of reference, what he's going to cover is what judges look for in submissions in commercial cases, procedural compliance in the commercial division, writing for ADR contexts, mediation, conciliation reports, professional courtesy and tone, AI in judgment writing. And we hope that at the end of the day, we will be able to align our writing with judicial expectations for clarity and conciseness. We should be able to understand how written submissions influence judicial decision-making and how to draft documents that withstand court scrutiny and of both procedure and precedent. Your Lordship, you are most welcome.
Thank you very much. My fellow panelists, participants online, good morning once again. I'm happy to be here this morning to have a discussion of how the bar interacts with the judges in the courts. But before I do this, I'd like to explain perhaps a bit on my experience in the commercial division. You may all be aware that it was a very short stint of only 4 years. Before the commercial division, I had served in Arua and in Gulu. But I would like to say that in the circuits, there's very little or limited commercial litigation. So when you get into the division, you dive into the deep end of commercial litigation in our country. The environment is so intense, it's so demanding, and the time is limited. Therefore, we rely a lot on the organized presentations of advocates. If you have advocates on both sides that interact with the court in a very focused manner, it helps a lot. My experience from the 4 years that I served at the division is that the quality of our submissions and interactions with the courts is declining. There's a very significant decline. And I'll be highlighting in my presentation areas where I believe we could have some improvement. You ought to realize there are 3 modes of interaction with the court. We do so first by our pleadings. Even before we interact with the litigants, we get to understand a little of who they are and the advocates representing them through the pleadings. So the first impression is created by the quality of your pleadings. Then we get into the second phase of oral interaction. Here, the advocate speaks as well as the litigant and their witnesses. We have a second opportunity to analyze the case through the oral presentations of all parties involved. Then finally, the last phase is the written submissions. It is the last opportunity for you to persuade the court to make a decision in favor of your client. So I've arranged my presentation around 4 areas. First, I'll be looking at the characteristics of commercial litigation, where I'll highlight the environment we are called upon to act as members of the bar as well as the bench. Then I'll look at the purpose of final submissions. I've chosen to focus more on the final submissions because that is where perhaps I could suggest some improvements on how we can make them more useful to the court. I'll look at the structure, some aspects of the structure of submissions, and some aspects of content of submissions. Now, as regards the environment, increasingly commercial litigation is becoming more and more complex. We encounter areas of the law where we never had opportunity to be trained. So you kind of self-train as you go along during the litigation. This happens with a bench as well as with a bar. We are students throughout our careers, so the moment you stop learning, the moment you stop discovering, is you become less effective in the court environment, whether you are on the bench or at the bar. Most of the cases we have are not limited to one area or discipline of the law. You can have one case covering contract, insurance, construction, mortgages, intellectual property rights, all in one. And you're supposed to isolate and also integrate all these different kinds of disciplines of the law and make out a case that is persuasive in the various aspects of the case. So what this means is that commercial litigation requires specialized approaches. Not every advocate will be effective in the commercial law or commercial litigation environment. You need to attune your skills to focus first on your grasp of the law, your organization of content, and the way it is presented. In the 4 years, I've discovered many advocates don't put in the expected effort. They bring a lot of volumes of documents unsynthesized in their trial bundles, dump them with the court, no explanation, no guidance, and then expect the court to get meaning out of them. It's a very difficult task for us judges when we get this kind of advocacy where you are not helped at all. Sometimes it's because you are busy as well. You don't have enough time to do it. But for us, we can't avoid it. You can't deliver judgment unless you've internalized everything that has been presented to you. There is no opportunity to ignore anything. You must take into account all evidence. So I think we could be assisted if the bar is more focused in arranging their evidence, simplifying it through witnesses, and also using some mechanisms of making it more user-friendly, which I'll be suggesting in due course. So let's take commercial litigation as a specialized area of practice that requires special skills and also requires constant improvement. The other aspect that is significant in this area is the financial stakes involved. It is big money in most of the cases. It is about the survival or collapse of businesses, livelihoods, and many other aspects. So this raises expectations all around. The bench expects that the quality of advocacy will be high. The litigants expect that the amount of time and skill devoted to the case will be high as well. So it is demanding in all areas of interaction. The other aspect we have, which I've hinted at earlier, is the kind of evidence we have to deal with. Many times we have volumes of documents covering hundreds, at times thousands of pages, which you have to skim through, understand, link, and analyze. We have a high incidence of expert evidence and how it is presented, and sometimes we have contradictory positions, especially in the area of valuations, projections, and as well as analysis of data. These areas sometimes present challenges of how to present and also guide the court through the evidence. Commercial litigation requires a lot of analysis, very detailed analysis of figures, of processes, of terms of agreement, and so on and so forth. So as you see, it's an environment that is taxing. It's an environment that requires a lot of focus and organization. At the very beginning, right from the time of presenting pleadings up to the time of closing your submissions. Most of the submission will receive written because of time constraints. Oral submissions are good for short applications, but they are not ideal for the actual determination of the dispute in the civil suit. So always prepare and improve on your writing skills, because that is the ultimate advocacy in that court. You will have very little opportunity to make oral submissions. Most of the time, it is written submissions. So that's the environment we are dealing with. Now, why do we have these submissions? I'm imploring participants to consider submissions first as a roadmap. It's like a blueprint. That is one use of submissions. When you are to build a house, you don't wait until the house is up in order to get a picture of what it should be. You first imagine what the house should be, then take time to make drawings and also include detail before the construction begins. The practice I've observed is to wait until the last witness has testified for someone to begin thinking about submissions. That is a wrong approach. Submissions begin after conferencing. That is the ideal moment to begin organizing your submissions, the final submissions. That is when you prepare your roadmap of your case. If you have a draft of your submissions at that stage, it gives you a guide on how to lead evidence, how to structure your submissions eventually, and it gives you a plan and litigation strategy that fits with your final or end goal. So I would recommend that you have draft submissions at the closure of conferencing, because at conferencing, you've seen all the documents that will be used in the trial. You've had opportunity to read all the pleadings on which these two cases are founded. You have read the witness statements and have an idea of what the case is on each side, and are in position to strategize in terms of presenting your case and also highlighting the weaknesses in the other case. It is at that point that you begin, or you have a draft of your submissions. Once you have your submissions as your roadmap, as your blueprint, the draft, then you keep monitoring the progression of your case, fitting the pieces of evidence that have come up during the trial into the areas that are proved in the course of your in the trial. Many times I've interacted with advocates and I've posed questions about gaps in their evidence and asked them to explain why some type of evidence is not, or expected evidence is not forthcoming. Then someone says, I'll address that in my submissions. And my response always is, you don't have a submission unless you have the evidence first. So there is a belief cases are won during the trial, not at the conclusion. If you reserve your submissions to the end, or for the end, you might miss out on leading evidence that supports your submissions. So that is one reason why you should have them at the beginning, a draft at least. Then, submissions are very critical, especially in cases which are raising novel points of law or unsettled law, or that have evolved very unclear facts. You are uncertain as to which set of facts should prevail over the other. Those are the best cases where submissions are very important for the judge. These cases are raised mainly in new areas of the law, new areas of practice, of businesses, especially transboundary kind of trade or situations. Here, submissions are very important. So you look at the nature of the case. If you find it has raised many new areas of the law or very significant novel areas of the law, then your submissions are critical. But if you've been dealing with ordinary issues that have a wealth of authorities where the law is settled, your submissions may not be as important because there is not too much controversy about the law. The facts are not so controversial. There, the submissions are not of critical importance. How do you tell? From the judicial perspective, when I fix a date for a judgment, sometimes I can write a judgment even without submissions because the law and the facts are clear. But there are moments when you would rather extend the time for submissions in order to have the input of the advocates because you have trouble making up your mind on certain areas, and you could make use of their insights and perspectives. So the more complex, the higher the opportunity you have to persuade the bench to decide in your favor. Don't waste that opportunity. Make the best use of that persuasive opportunity by focusing on what is important in your submissions. And that is why in the last bullet I'm saying that in submissions you are focusing more on persuasion than quantity, making points that have to be made, supporting them well to the extent that is necessary, and avoiding clutter. You are writing to persuade, not to impress. It's not about quantity, it's not about volume or wealth of authorities you have. It is how effective you are in communicating what you want the court to understand about your case. So Focus on persuasion. How convincing your submission is more important than how scholarly it is. It is how you weave the facts and the law together in a very candid manner that matters the most in your interaction. Next slide. Now we move on to structure. Once we know the purpose, that we need to persuade, we need to convince, we need to take opportunity, we need to guide. That is the purpose of submissions. How do we structure to achieve all these purposes? First, you imagine yourself writing the decision. How can you gauge that your submissions have been effective? Compare your submissions to the outcome, the written decision. How close is the resemblance between the organization of your submissions, the content of your submissions, and the final outcome? The further apart they are, the less effective your submissions have been. The closer they are, the more effective your submissions have been. I've had complaints sometimes of advocates saying they write multiple pages of submissions and they don't see the arguments reflected in the decision. That's a clear indication that perhaps your submissions have not been useful in guiding the decision of the court. I'll give tips on how to guide the court rather than have a situation where your submissions are all more or less ignored or not used. We read them many times, or most of the time. We try to read as much as possible. But if you read the first few pages and they are not helpful at all, you are not encouraged to read further. You rather do it on your own. Do the research on your own, because it's a waste of time. The submissions are not guiding at all. Instead, they are kind of cluttering the thought process, and you'll be doing double work, reading the submissions and then doing additional research. Useful submissions, you only read to verify, because the information is useful. You only need to verify that it is accurate. If it is not useful at all, you disregard and do your own research and write your own decision. That is where the quality is reflected. Look at the decision that has come out, compare it with your submissions, and see how much of it has influenced the decision. How do you achieve that? Write with the mind of an advocate. You are not writing a novel. I've seen and I've complained in some of my decisions that right from the pleadings, someone is narrating a story like a storyteller, with no analysis, with no focus on what has to be decided. You don't see a legal mind at work. You see a storyteller's mind at work, narrating events chronologically without organizing them in a manner that makes out a case. So always remember, you are an advocate, you are not a storyteller. You should be able to highlight or to sieve out the material aspects of the events and eliminate what is unnecessary. So how do you do it? The first, in bullet 3, is have a clear case theory, a summary of the case that you are presenting. The summary is built around the elements of the cause of action you are asserting. If the first element is that there was a contract, there must be proof of a contract. So it's about date of the contract, the parties to the contract, and the key terms of the contract. Those are the clear aspects you need to have in your summary. Anything else about that aspect is irrelevant. If the next element is breach, Again, you highlight when it occurred, who was responsible for it, and how or circumstances in which it occurred. So you are limited by what you have to prove if you focus on the elements or themes that you have to prove in that case. The bad submission just tells you a story of what happened from the beginning up to the end without focusing on those elements. Then make sure that after the summary that your submissions are responsive to the issues. So it is a layered process, issue after issue, and in the issue, make a logical progression of your argument. There are foundational aspects of the case. Then there's an analysis of those foundational aspects, and then a conclusion at the end. It should be having a logical flow in each issue. It helps to separate your submissions into sections. I've read many submissions which have only the heading at the beginning, and thereafter only paragraphs, no subheadings. It's like you are reading, even novels have chapters, but many submissions don't have subheadings. So apart from issues, what they do, they only have issue 1, 3 pages of writing, or 5 or 6. Another issue, multiple pages. Even within the issue, you need to break it down into small components, so focusing on what has to be discussed, resolved. So if you have an issue, first state the law. What is the law? Is it settled, or are there contradictory or divergent opinions on that issue that you are aware of? Highlight them. Some points of law are settled. There are decisions of the Supreme Court that have withstood the test of time. You don't have to cite many. One will do to support your point. Some points have divergent opinion, especially of the High Court, and there is no binding or settled position. Cite a case or two illustrating the points of divergence on that point. Some are novel, where we don't have any local authority, and you have to look for authorities from outside or other jurisdictions. Again, point this out and explain why you are citing that authority and how persuasive it is. That is the marking of the first level of your analysis, awareness of the law and the status of the law. As a judge, I'm looking out to see if you are stating the law correctly and that you are aware of the position of the law in our jurisdiction. Do we have settled law on that point? Do we have divergent opinion on that point? Or is there absolutely no settled or source of law internally that we must look for solutions elsewhere? That is the opening part of your issue. Then after that, you make your point. What is your point about that issue? It should come out clearly. Why should the court decide, and how should it decide in favor of your client? Once you've made your point, then justify it by weaving fact into those principles. Which facts favor your case? Which evidence have you adduced? And how much weight should be attached to your side of the case? Sometimes you begin with a defense case because you want to attack it if you are for the plaintiff. This is the defense case. You state it first before you turn to yours because you want to end on a high note. You begin by attacking or undermining or discrediting the defense against your case, then ending with your strong position. I'm arguing that the court should decide this way, but I'm aware the defense argument is as follows. But that is a wrong argument because it is not supported by this evidence, or it is a wrong principle that they are applying. The correct position is this. So you end on a high note of emphasizing your point, rather than beginning by presenting your case and then ending by discrediting the case for the other party. That kind of overshadows the strong position of your case. I would recommend that you begin by highlighting the weaknesses in the opponent's case and ending with the strength of your case. That leaves a better impression of, on the bench. In complex cases, it is very useful during the trial to present a breakdown of the evidence by using graphs, using charts. I decided a case recently whose judgment took me 2 weeks to write. And the main reason is that I had to read 600 pages of documents, most of which were to do with the importation of certain equipment. I had to extract dates from those documents, to sort them out by type, which are bills of lading, which are clearance documents, tax clearances, which are customs documents, which are shipping documents, classifying them, getting dates out of them, identifying subjects of that shipment, what was being shipped, and also putting a value to each of those consignments. It was a very tedious process. I could have been helped by the advocate in that case, extracting all this information. First, arranging the documents in a sequence that makes sense, category by category, then giving me a table of a summary of what each document contains. This is a packing list, dated this, covering this number of items, whose value is this much. Then you tabulate that information and present it as part of the documentation you are presenting to court, as well as incorporated into your submissions. It makes judgment writing more focused and easier if you do that. Many times we are left to grapple with this synthesizing of documents. For us judges, you can't, as I said earlier, gloss over this. You must do the analysis the difficult way. So if your submissions have a habit of doing this, it is likely judges will be eager to read them because they know you have a practice that helps them follow your case. But if you've built a reputation of submitting documents that are not organized in this manner, that are not analyzed, there will be very little encouragement to read submissions in great detail. You'll just skim through and see if there's a point you can pick and use. Then there's also a tendency of not linking your submissions to the pleadings. As you're analyzing the facts, it is recommended that you start with the pleadings. What was pleaded about that issue? Did the evidence prove what was pleaded? To what extent was that proof submitted or provided? Or if it failed, where are the failures? So you start with the pleadings, link it with the evidence, and then integrate it into your conclusion. And illustrate how and at what extent each of these elements has been proved. Always remember there are standards of proof that are important in some situations. For example, if you are dealing with fraud, or cases of forgery, you should be aware of the heightened level of evidence that is required. Has the evidence met that heightened expectation? And lastly, as you draw your conclusion, can you help the court to quantify what ought to be awarded to your client, if it is quantifiable? If it isn't, what is the basis of the relief that you are seeking? Again, this area is neglected many times, and you leave it to the court to come up with these assessments. It is, I think, necessary that you have an input at that stage as well. Then, when we come to some of the attitudes that are important in interacting with the court, we are human, just as you are. There are things that impress us. There are also things that kind of put us off as decision makers. Each judicial officer has their own temperaments. But there are three that I'm recommending you always consider. The first is the ethos, credibility. For some judicial officers, the moment you are found unreliable on any aspect as an advocate, you've lost it before that court. You will never be taken seriously for the rest of your practice. There are others who are tolerant. They may accept some level of insincerity. They will call you to order and move on and forget it, provided you respond positively. So if I find a non-existent authority in your submissions, why should I ever read your submissions in future? If you are the kind of advocate who creates decisions that have never been in any court of law. Credibility is important. So some judicial officers will not take kindly to this practice. Others will be tolerant. So who are you dealing with? And how candid? What extent of credibility is required of you as you present your case? Then the pathos, the emotions. We are all emotional beings. But some people can control their emotions. Others let their emotions overcome them. If you have a case involving a collapsing business in the commercial court, what is the attitude of the judicial officer towards a person in that situation? What is the cause of the failure of this business? And how does it ring with this officer, judicial officer? The reason for your predicament is obligations. You borrow money, don't want to, and then bring up a lot of excuses to put up the judicial officer, or are they sympathetic to people in that situation? Some judicial officers will show it, others will not. It will not be relevant to them that you hammer that point at all. The more you bring it up for others, the more your case is weakened, because it presents your client as a person who is taking advantage of trust that was placed in him with other people's money. So, to what extent can you play the emotional side of your case to win a decision in your favor? Always gauge the temperament of the judicial officer. Some might be sympathetic, others will not be moved by emotion. So you don't waste your time playing the emotional card. Then logos, the reasoning. I think reasoning is important for all of us. How organized and persuasive your submission is will appeal to any judicial officer. The emotional aspects you can't tell. Credibility aspects you can't tell, or sometimes you can. But with reasoning, that one no one will avoid. The stronger your reasoning, the more likely to succeed. So improve on the rational process of the interaction with the court more than the emotional and the credibility aspects. Credibility is important, but it is mainly reflected in how candid you are in citing authorities and addressing weaknesses in your case. That is where we gauge credibility most of an advocate. But reasoning, you can't avoid it. There are submissions you read and they don't make a lot of sense, or if you are to draw sense out of them, you need to think a lot, read over and over again the same paragraph before you get the meaning of what someone is trying to put across. So make sure that you are clear, clarity is important, and that the conclusion is supported by the evidence you have. Sometimes we forget the exhibits. We don't advert to them in our submissions. Sometimes we forget to quote witnesses fully. We are selective in what we pick in our submissions. You pick out a statement and exclude the context in which it was made. That reflects badly on credibility. Acknowledge the statement, its strong points and its weak points. If you are to rely on authorities, highlight them. Some decisions are long and in small print. Some books you cite or articles in journals also have those limitations. So it helps if you can highlight. If I see the point you are making, then I decide how much further to read or how much more to read around that point from the same decision, because I can identify quickly how important the point you are making or citing is to my decision. If I find the point is good, I may be enticed to read the entire decision. If I find it is partially useful, I may decide to read a few more paragraphs to see the context in which it arose. So highlighting, but if there is no highlight at all, I may ignore that decision unless I have a lot of time to read it. So keep your language clear and simple. Remain credible and grounded in your evidence. Acknowledge facts which are weak in your case and explain why they should not carry too much weight in the decision making, and emphasize the strong points in your case. Never ignore the weak points in your case. And always be professional. I've seen submissions where the advocate is almost quarreling with the witnesses, sometimes the judge, or the other counsel, the opponent. This advocate is lying, or this witness is a liar, is a thief, is that kind of thing. You don't make that kind of argument. It does not carry any weight. Don't be emotional in your submissions. I wish I had more time, and I would recommend perhaps that next time we have a practical session where we illustrate these types of occurrences and how to deal with them. I think I'm encouraged now to assemble something more constructive in this area to illustrate practically on areas of improvement. You know, talking about them theoretically, I don't think is as impressive as you have illustrations and critique in a physical environment. I think that is a better way of dealing with these submissions. So don't engage in inflammatory statements. Those types of statements are unnecessary. That more or less covers what I had prepared in terms of submissions, but I would like to digress a little into the two other elements that I was invited to speak about The first is AI. How do we apply AI in judgment writing and in submissions? AI is recommended both for the bar and the bench, but with caution. You should be aware that these are programs by humans that are arranged to originate thought, so to speak, of their own, based on the data that has been availed or is available to them. So they have limitations. You should never let AI take over your human discretion, because it doesn't have it. The final output should be cross-checked and double-checked to make sure that it is not misleading, it is not limited, and it's up to date. But I've found AI very useful in two aspects myself. If I have a point of law, an argument that I think should be presented in a particular situation, I type in that argument and test whether it is sound or not. It has been very useful for me, because once you do it, you interact with AI, with your argument. This is the argument I want to present. Then it will come back with an affirmation or a critique of your position, and also provide some sources you can cross-check. When it affirms your position, cross-check the sources. Where are the sources on which this affirmation has come from? How reliable are those sources? Once I test it with those sources, and I see that my argument has been affirmed and makes sense, then I adopt it and also have some. I've found this to be useful when I'm faced with a novel area of the law where I've failed to find any useful authority. Or if I've found authority but whose level of how binding it is in our jurisdiction is doubtful, I find it very useful in that area. Then the second area that I've found AI to be useful is in drafts. If I want to, or even summarize those two areas, if I need to draft something, I just use a few points, summarize a long passage. And that is where ECMIS has been very useful to me as well. I simply have to download your submissions, feed them into software that can summarize your submissions, and within a short time, I make out the points you are submitting to the court, and I can find them in your lengthy document if I need them, because I know now what your arguments contain. I recommend that you can use it as well for that purpose. If you get submissions of your colleague, seek soft copies as well. Use AI to summarize them. Then you understand what they are saying. If you have a very long exhibit, a document with so many paragraphs and clauses, you can also use AI to do the same thing, to summarize it. So it is a useful tool, but it has to be used with caution as we go along. The final decision is yours. The other point was? Yeah, in terms of ethical considerations with courts, no, there was also ADR rating. I've not done too much ADR. I wouldn't say I'm the best person to speak about this. So forgive me for not making any presentation on this part. I was at the commercial division, but ADR was being handled by colleagues mainly. I handled mostly litigation. I was only supervising. I can't say that I have a personal experience with this area of practice. But professionalism and ethics is something I can speak about. In the division, I observed that we have reasonable respect for the bench, but sometimes not as much for one another at the bar. You would have situations where advocates tear one another almost apart, and you have to intervene to maintain order in the court and also to emphasize that they should respect one another. I think the level of professionalism at the bar can be improved in terms of respect for one another and also respect for seniority. I've seen advocates relatively young in the profession who have no respect for the seniors at all. I know as part of the radical bar, decorum is not something you're very comfortable with or you think is used manipulatively, but I think it brings some kind of order. You know, in a system where there are no rules of behavior, very quickly you descend into anarchy. They may not be acceptable to some. I could understand why, because some people have abused their positions of seniority and otherwise, sometimes even the position on the bench, to mistreat practitioners. That is where decorum is abused. But the principle itself is good. How we use it or abuse it is what we should address. We should not do away with etiquette, with decorum in our court system. We should only manage those who take advantage of their positions to mistreat or abuse others not in a very advantageous situation. I thank you all. I hope my interaction with you has been of some help or useful to you. I look forward to receiving any responses or questions. Thanks a lot once again.
Thank you so much, Your Lordship. You have shared generously of yourself. Those in the virtual audience, please show some love. Use the react icon there. Yes, thank you very much. Thank you very much. Thank you, Your Lordship. I would like to highlight some of the big things that have come out of the presentation. Maybe I should go to the chat box first. I see Tumusime David says, wow. Andrew Mumpenje says, this presentation by Justice Mubiru, especially on how to write submissions, has been very helpful. And Esther Chisembo is, I think, talking about Justice Mubiru has just offered to give us a physical and practical session on legal writing. So let's all gear up, because the next session of legal writing is going to be a practical session with Justice Mubiru. Thank you so much, Your Lordship. About AI, I am so glad that you somehow gave permission to members of the bar to use AI, because it's a debate. Does it take away from human judgment? Is it making us dafter as lawyers? Is it improving our efficiency? Those are debates that keep on going on. And like he said, AI is a tool that can enhance your efficiency, but you cannot oust the need for human judgment and oversight. So whatever you get out of it, please make sure you cross-check. Otherwise, the courts are penalizing. I don't think there's been an experience in Uganda. Has there been a case where the court has penalized an advocate? But out there are many cases where courts are actually penalizing advocates for careless, reckless use of AI. The other things that were highlighted are, you need to help the bar. Like, it's not enough for you to just throw whatever documentation you have at the bar. It's your case, it's your client's case, you're paid to do the work, so do your best with it. Make the work easy for the bar so that you get the result that you want. Otherwise, if you bias them with unorganized work, then you're going to get a result that you don't want. I like that he highlighted the fact that judicial officers are human beings, and we should be cognizant of the fact that their temperaments can affect the outcome. So you are not going to operate as a robot. You need to be cautious of this. And credibility, emotions, and logic and reasoning should be at the back of your mind when you are presenting. There were so many nuggets that you shared. You are writing to persuade, not to impress. Then you are not writing a novel, a love story. You are writing as an advocate. So make sure your presentation shows it, your submissions show it. I would like to entertain some questions. I don't know if there are any questions. Thank you. Kasami Paul says, thank you, Your Lordship, for the enlightening conversation. What are your views on the front loading in submissions, and how does front loading affect the quality and efficiency of submissions? Your Lordship, would you like to take that?
If I understand the concept, maybe you need to explain what you mean by front loading. My understanding of it is that you promise a lot which you fail to deliver on. You make conclusions that are not supported by evidence. I don't know if I've understood it correctly. But if that is the case, no, I think I need to get an explanation first. Whoever wrote that question,
Mr. Kasami Paul.
Can you explain what front loading is in that context before I can address it?
Mr. Kasami Paul, please give us further and better particulars about front loading before His Lordship can answer. In the meantime, I'll read other comments. Lydia Antono says he has been spot on. Kara Victor says good presentation and very good to see that he has spoken about AI. Looking forward to the practical session with Justice Mobiru. How do you even follow up on that presentation? That is David Tumusime. Thank you very much. James Kiza says excellent. Ivan Okuda says very good and useful submissions by His Lordship.
Okay, I think he has explained it now.
Okay.
Okay, that's the way I understood it, where you state a position and then justify it afterwards. I think that is the best way to guide someone through your presentation or argument. They should know where you are going first, what you are trying to prove first. Then they can follow you. You know, it's difficult to follow someone whose destination you can't tell. Following that person will be difficult. But if you know where they are headed, then it is easier to follow the argument. That is my recommendation, that you do it in that manner. If you say the evidence has proved that this person breached the contract when they fail to do the following, then I know your argument is about breach of contract in a very specified manner. Then your justification, I'll be looking at whether what you are using as justification ties in with the modes of breach that you've already stated. It is easier to follow the argument when you front load. I agree. Okay.
Chris Angola says, refreshing presentation with valuable insights and practical illustrations. Most obliged, Your Lordship. Muhumuza Bashir says, thank you, Justice Mobiru, for the wonderful presentation. Truly spectacular and rich in insight. I think we should go now to the next presentation. Which is by Miss Olivia Chalimpa Matovu, who is going to handle persuasive advocacy and legal pleadings. And the terms, what we expect is how to structure pleadings that persuade, balancing brevity with detail, common errors in written submissions and how to avoid them, ethical boundaries in advocacy writing, the place for AI in drafting pleadings, and that has been handled a bit. And at the end of it, we should be able to craft pleadings that flow logically and carry persuasive weight, identify weak drafting and self-edit effectively, and apply ethical standards in written advocacy. Madam Olivia, the mic is yours.
Thank you, Zubeda. Good morning, colleagues. Good morning, my Lord, once again. I thank the Uganda Law Society for inviting me to share my views on that topic, as she has demonstrated. So I'll be speaking about advocacy, sharing some of my ideas, and hopefully I'll speak more ideas from some of the practitioners on the call. I'll speak from the trial advocacy point of view, because I do also train trial advocacy. So here I'm going to be speaking about how you present your case through pleadings. I'll speak briefly about submissions, but mainly through pleadings. So that will be the content of my presentation. So in brief, I'll begin by, as lawyers do, what do you mean, by defining what advocacy is and what I understand advocacy to mean. In my view, advocacy is the art of presenting a client's case to a tribunal or a court, or in any other mode anyway. You can, there are many forms of advocacy outside litigation, but generally speaking, advocacy is the art of presenting your position or your case. And what would amount to persuasive advocacy? I've summarized it here. To be persuasive, you must be clear. I think you heard Justice Mubiru just right now when he said, when you're presenting your submission, you front load. You begin with your position and then justify it, so that then the court can follow through. So you must be clear, where are you going? Then you should be concise. Many times we can get lost in translation because in your advocacy, you're speaking too much, but not bringing the point home. So it's important that as you present your client's case, you go straight to the point and it's concise. It's not verbose to make the court lose track of what you're leading to. There is need for coherence. Are you coherent in your argument? And in that way, I would like to say that advocacy begins at the point of pleadings. I think you had Justice Mubiru when he was presenting, he said when you're making your submissions, he advises that you refer to your pleadings, indicate in your pleadings, in your submissions, where you pleaded what you're trying to argue about, and then look at the evidence and then the go position. So it's important that you're coherent from the beginning. What are your pleadings speaking about? What is your cause of action? Is it clear from your pleadings? So it's important that in your advocacy, you're coherent. Then you must be compelling. The judge says we shouldn't just impress, we should persuade. So for you to be persuasive, your arguments must be compelling. They should be justified, backed. For instance, in your pleadings, many times you'll have a plaint, for example, and you'll have, let's say, documents that support what you're speaking to in your pleadings. So for your pleading to be compelling, you must have, usually we attach annexures to our pleadings to demonstrate what we are speaking to. So by the time the judge is hearing your case, they have an idea from your pleadings of what your case is about, because you have pleaded and attached relevant annexures that speak to the point that you're making. The other aspect of persuasive advocacy is it must be complete. Your argument or your presentation should be complete. At times as lawyers, we might make points in our pleadings, but we do not have, like I said, maybe an exhibit that supports to complete your story. So while we make those statements in the plaints and defenses, we don't have what it is that would complete the argument that we are making. So for you to be persuasive in your advocacy, you must make sure that your arguments, your presentations are complete. There is a logical following through from the start to the end, and something is not left hanging. I've had experiences in my own practice sometimes when a case is brought probably to the firm. Initially, probably you're speaking to people or a representative of the client who has brief facts of the matter but doesn't have it in completion. So as you go along the case, you start realizing, as you start interviewing some of the people who would be possible witnesses, you start realizing that at the time of pleading, you probably did not understand the case. So my recommendation would be for you to have a complete view of what your case is and to properly be persuasive in your advocacy. You would need to engage a party who has the complete facts that would enable you plead your case appropriately, and that would guide in your production of evidence and in your submissions at the time when you have to make submissions. So it's important that you have a complete and holistic view of what your case is from the very beginning, from the time of pleadings. I know we have a right to amend, and that right is continual, but it's important that even as you're amending, the story is coherent. You're not amending to jumble up facts to rebuild the case, but you have a coherent story and a complete story. And then persuasive advocacy also requires logical structuring, and I think the judge spoke about it in submissions. He talked about submissions being structured. So should pleadings be. As we plead our case, you must start from the beginning. What transpired as you tell the story of the case, from the beginning to the end. Instead of beginning with for example, you can't begin your story with the remedy without showing why you're entitled to the remedy. As you all know, for pleadings, you must demonstrate a cause of action. First, establish a right. Did the right exist? Was that right breached? And if it were, is your client entitled to the remedy? Was it the defendant that was responsible? So there must be a logical structuring of your pleadings such that the judicial officer is able to follow from your pleadings and from when they read the case that the case of this party started like this, and this is why it ended, and this is what they want from the court. I have indicated on the right-hand side some provisions of the law in terms of what it is under the law that enables us to present our case in court. So as you can see, I've just gave a summary, and that I'm sure you are aware. I just wanted to quote that so that you can know that you can present your case through, as the Civil Procedure Act provides, a petition or summons, including statements, a plaint, a defense, a reply to the defense, counterclaim. So those are the modes of some of the modes of presenting your case to the court, and it's where you make all the different steps that I've given you. It's within the plaint, it's within the defense that you ensure that you're clear, you're concise, you're coherent, you're compelling in your presentation is complete, and that it's logically structured. So how should pleadings be structured? I'll take you to Order 6 of the Civil Procedure Rules, which usually guides us on pleadings generally and makes requirements. So as we draft pleadings, we're not storytellers, as the judge said. We are advocates, so we have to refer to the relevant laws. What does the law expect of a pleading? What should be pleaded in a particular, in a plaint, stating a particular cause of action? So it's important to always go back to the rules and ensure that we are following through. For example, you must ensure for some cases, like when you're pleading fraud, you must be particularized. You should have particulars of the fraud complained about. For negligence, you must have particulars. Bad faith, you must have particulars. We also know that for special damages, for you to claim special damages, you must particularize the special damages. So in structuring your pleadings, we must ensure that as we go through the chronology of events, we are also looking at the relevant law that guides on what is expected of a particular pleading in respect to a particular cause of action. And as we go through the chronology, we have had situations where you have pleadings that do not disclose the cause of action. And that's because there is no proper understanding of what the client's case is. So a good pleading must disclose the cause of action as provided for in Order 7 if it's a plaint. And we know that under Order 7 of the Civil Procedure Rules, if the plaint doesn't disclose a cause of action, you lose the case at the very start. Even before you present your client's evidence, the opponent will raise a preliminary objection to strike out the plaint, and the plaint will be rejected and struck out. So it's very important that as we prepare our pleadings, we must ensure what is the cause of action that I've highlighted. Is it negligence, for example? Is it fraud? Is that what my cause of action is? Is it recovery of property? So, and have I clearly demonstrated in my pleading recovery of property? Other than seeking a prayer, but when the judge looks through the pleading, the cause of action is not clear. Good pleadings must deal with each allegation of fact, and that's where the chronology comes from. So each allegation of fact, a pleading must clearly state it. Instead of jumbling them up, state the facts chronologically in your pleading such that the judge can follow through. And what are the demonstrations of bad pleadings? I've talked about failure to disclose the cause of action. Bad pleadings are argumentative and emotional. The judge talked about us avoiding being emotional. You read some plaints or defenses and you clearly see a lawyer is arguing in the pleading. Or you see a lawyer is emotional in the pleading. They are actually quarreling within the plaint, calling the other party names, using certain language, and yet it's supposed to be neutral. So pleadings must not be argumentative. They should avoid emotional statements, but be specific, stick to the facts of the case, stick to the cause of action, stick to the remedies sought. Every pleading must contain what remedies are being sought by the opposite party. All right, so I now speak to some of the legal provisions that guide us. Just a minute. Okay, that guide us in preparation of pleadings. When you're preparing a plaint, reference will be made to Order 7. What is the plaint expected to have? And what happens if the plaint doesn't have some of the contents of what is required of the consequences of that? For the defense, we have Order 8 that defines what defenses are, but specifically, the Order 8 provides that defenses must have specific denials. You can't have bare denials or general denials in a defense where you generally deny the claim. But the law requires that you must be specific, deny every allegation of fact as presented in the claim, and specify what your defense is. So it's not enough to just deny the claim, but what is your defense to that claim? It's important that in your defense, you're very clear. And then obviously the counterclaim is as good as a plaint, so you must specify the facts that lead to the rights that the client is claiming, and then what remedies are being sought via your counterclaim. I speak to affidavits briefly, which affidavits, the law is clear that affidavits should be confined to such facts as a deponent is able to depone. And many times in practice we find that affidavits have been thrown out because they are based, the deponent is not in the know, is not the person who had the knowledge of the facts. So they are speaking to something that they don't have knowledge of, and they don't specify the source of the information that they are deponing to. So it's important that the deponent has the knowledge without being specific about what the contention is that you're appealing against. Contention is that you're appealing against. I will ask the IT team to display the presentation. Okay. Please allow us to proceed as the presentation is being loaded. Okay. So I've given you a demonstration of one of the cases where a good pleading was looked at, the Simbak Manual Estates versus Equity Bank. And it kind of highlighted what is expected of a good pleading, which is that it should narrow the controversy by identifying the precise issues in dispute for trial. So from the pleading, from a plaint or a defense, it should be very clear to the opposite party and to the judicial officer what the issues for trial are. The next thing about a good pleading should appraise the opposite party and the court what the matter in dispute is. So the dispute should be clear. Like I said, is it an issue of fraud? So it should be very clear from the pleading. We've had situations where you hear the defendant asking for further and better particulars, and that arises because the plaint was not clear in terms of what was in dispute. So the other party is seeking further and better particulars of what the dispute is about. So a good pleading must appraise the opposite party and the court on the matter of dispute. A good pleading must contain material facts which are essential to establish a cause of action. However, you should not delve into evidence. At times, there's a temptation to plead as if you're leading evidence, and you find that the pleading is front-loaded with evidential matters instead of actual concise pleadings of fact that establish, let's say, cause of action or a defense. So it should be simple, it should be concise, and it should be direct. The overall object is to ensure that there's clarity in the pleading, there's precision, fairness, and it should enable an efficient and just trial. And that can only happen if the pleading is very clear. What would amount to a bad pleading? A bad pleading would include unnecessary details. For example, in the pleadings, you're quoting, let's say, cases and laws. So in your plaint, instead of detailing the cause of action, you go ahead to actually start even quoting, citing the laws and the evidence in the pleadings. Point in time, it can be cited at the later stage, especially in submissions and during the trial preparations. Pleading should avoid unnecessary repetitions. So that's where we're talking. I was speaking about being concise. So for you to have good persuasive advocacy, unnecessary repetitions should be avoided, and I think this, my lord, spoke about it in submissions as well, because when there are unnecessary repetitions, you turn the other party off, and the court, they fail to follow through the case of your client because you're repeating yourself. Bad pleadings are too narrative. Whilst you must speak to the facts of the case, avoid a narrative that is like a story. As already been told, we're not storytellers, so we speak in summary about the facts of our clients, but not going through an entire story of what, let's say, transpired at a particular day or time, but you speak to the summary of what the case is about. So what are the consequences of ineffective advocacy at the pleading stage? One of them is that you will have your case struck out. For example, in this case, the plaintiff was struck out because he did not disclose a cause of action. Like I said earlier, when you have no cause of action in your pleading, your case will be thrown out. So persuasive advocacy requires that your case, the matter in dispute, is very clear. If it's not clear from the pleadings, the case will be struck out. So you lose from the beginning. You have not persuaded anybody about your case. In terms of defenses, persuasive advocacy requires that your defense is specific and they are not just bare denials. And here I give you a case, one of the cases where a defense was struck out because it was bare denials, and if it was the defense was evasive. So it's very important in persuasive advocacy as a defense counsel to detail the grounds of your defense. What is the basis of your defense? What is the basis of your denial of the plaintiff's claim or the claimant petitioner's claim? What is the basis of the denial? It's very important that defense or any opposition details that. And then regarding appeals, I've also demonstrated a case where an appeal was thrown out because the grounds of appeal were not specific in terms of what they were complaining about. And like I said, under a Court of Appeal rules, there's a requirement that the grounds of appeal must be specific, should not be argumentative, but must be very clear about the complaint regarding the judgment that is being challenged. So once the grounds of appeal are not clear, the Court of Appeal would strike out your memorandum of appeal. So persuasive advocacy requires that in preparation of the memorandum of appeal, it's very clear what part of the judgment you're contesting, what wrong was it, where did the judge err, or where did the judicial officer err, and specify what it is that it was. For example, I'll give an example of a ground of appeal, I think, which the courts have found to be very unclear. Many times I think we put a ground of appeal of the court did not properly evaluate the evidence, and it's not very clear which part of the case it is that you're referring to, in what aspect of the trial, or which evidence it is you mean that was not properly evaluated. So it should be with a specific claim in respect of what part. For example, if it was evidence regarding fraud and the court did not properly evaluate evidence of the witness, then you're specific to that part of the claim or in that memorandum of appeal. And then the other thing that I'm expected to speak about is brevity. So what is brevity? Brevity is the presenting of material facts and arguments clearly and precisely without unnecessary elaboration or repetition. So basically having a summary of what you're speaking about in a very concise manner. And what are the limits of brevity? A pleading will not be deemed to be adequate if it merely refers to material facts without stating them fully enough for the other party to understand the case to meet. So whilst we are required to be concise, it's very important that we balance brevity with some detail. So it's not enough for us to be very brief where we don't explain, for example, what justifies the claim that we are making. So it's whilst we advocate that you must be concise, the concise should have enough detail that will enable the other party understand the case they are meeting, but that will also enable the court to understand what case is being pleaded. And that is why in certain complex matters, you're required to even particularize them to avoid a claim, for example, that the party was negligent and there are no particulars being indicated. So there has to be a balance between brevity and detail. And as advocates, we need to be able to balance that in preparation of our pleadings. Sorry. Wait. Sorry about that. I see the slides seem to keep moving. I need your assistance. Colleagues, hold on. Let's first sort out this issue. So as the presentation is being organized on the IT side, I would like to say what the pros and cons of balancing brevity with detail are. So in terms of brevity, what are the advantages of you as an advocate following the principle of brevity? it allows for concision. So for you, you'll be concise, and like we said, sometimes human beings don't have a lot of time to read too much information. So with with brevity, you're able to summarize whatever points you're making. Brevity enables arguments to be easily understood. So when you're straight to the point, it's very easy for your argument to be understood. Unlike where you go around, for example, like the judge said earlier, you present your point and then justify it. If you begin with the justification, before you show where you're going, the judicial officer will not be clear where you're leading, neither will the other party. So brevity enables you, go straight to the point, and then the detail will allow you to demonstrate how you justify it. It demonstrates ability to present complex cases succinctly. You're able to present a complex case in a summarized manner and a way to easily understand. Some of the disadvantages of you being too brief is that it may create room for ambiguity. So that's the point where I recommend that you must have your point summarized, but then some facts that detail the justification for what you're making are indicated. So begin with the summary of the point and then indicate the justification immediately thereafter to enable the other side or the court to understand. And then there is room for clarity when you add some detail to your argument. Avoid lengthy presentation. So in terms of summary, you summarize, give a justification, and that's it. Avoid having to tell an entire story of the case in your pleading when you have a chance at trial to lead evidence and in submissions to bring everything together. So it's very important that when we are preparing our pleadings, we are balancing the two, brevity with a little detail, to ensure that our case is very clear from the onset. So what are the common errors that we find in our submissions? So now I'm moving on to submissions, and I think the judge has already delved into that and discussed it generally. But I would like to share some of the errors probably that have also fallen into, or which probably I've also seen colleagues fall into. The judge talked about a submission having a theory. But one of the errors we find sometimes that there are fanciful theories being presented in submission. Sometimes because we are presenting theories for our case, we present fanciful theories in our submissions. So those are some of the common errors. And once we present a fanciful theory, we are not able to prove that theory with the evidence that we presented during the case. So it's very important that we avoid fanciful theories on non-existent evidence. Then there are submissions that fail to address issues that were raised. And you find that issues that were raised at trial, in submission, somebody has kind of changed the issues just to suit the evidence that they adduced. And that comes from the fact that from the time of pleading, the person was not very clear about the case they were pleading. And then when it comes to trial, the evidence that the clients have presented with them seems to be different from the case as pleaded. And now at submission stage is when an advocate is trying to remedy the defects that were in between the pleadings and the evidence that was adduced. And as you've heard from the judge, it doesn't work. You must follow your pleaded case in your submissions. It means that also the evidence that has been adduced in court must be evidence that supports the pleaded case. And that's why we've had objections like departure from pleadings, because a party has in evidence departed from the pleadings and at submission stage is now submitting on issues that do not address the dispute as was raised in the pleadings. The other common errors that we find in written submissions is raising new matters which were never addressed at trial. So you find that as advocates, we forget probably to raise these issues during the trial, and it's because we didn't prepare well in terms of how we pleaded our case from the start, in terms of how we led evidence at trial, and now at the submission stage, we realize there was something that we could have raised and now want to raise it during submissions. That is a common error that the other parties usually object against, raising new matters that they were not given a chance to lead evidence on and effectively submit. And then failure to cite binding authorities or relevant authorities. That's another error. And here I give an example of where you find you're citing cases of lower courts in a higher court. I know that there are times when the higher courts will approve a case of the lower court, but when you're citing it there, you must clearly state and persuade the court to actually affirm or approve that decision, because ordinarily that decision is not binding. So at that point, when you cite it in a higher court, it's only for persuasive purposes. They are not bound. So it's very important that in submissions, as advocates, we avoid citing cases that are not binding on the court in which we are appearing, but ensure that we cite cases that are binding, or if they're not, if you can't find a case that is binding, then make sure that that case is persuasive enough to persuade the higher court to actually approve that case and rely on it, and thereby make it binding on them. And then the other common mistakes are failure to refer to exhibits. At times, we tender in evidence during the trial, but in the course of the written submissions, the evidence by exhibits is forgotten, and probably the party only refers to the evidence, the oral testimony or the testimony in the witness statements of the party, but forgets to relate the exhibit evidence to the case. So it's important in persuasive advocacy to ensure that we weave the entire thing. If we produce evidence of a witness, it's relied on. If produced evidence exhibits, the exhibits are relied on in the submissions to further prove the case that has been presented on behalf of the client. How do you avoid the errors that I talked about? You must be guided by your pleadings, and I think that I won't overstate it. As the judge said, refer to your pleadings and then refer to the evidence, and then you submit. So the pleadings guide in submissions. Understand your case to enable you to distinguish unfavorable case law from your facts. Be able to understand the case clearly and then distinguish inapplicable, in fact not unfavorable case law as such, but irrelevant and inapplicable case laws, because sometimes you might find that a case has been cited by the other side, but it doesn't apply to the facts of your case, and you're able to distinguish it from that point, much as the principle being highlighted in the case might be a principle that is applicable to generally the cause of action that was raised in the pleadings, but that particular case, in terms of the decision and the rationale of that decision, would not apply to the facts. So if you understand the facts of your case, it gives you a position to be able to distinguish that case from your case, and therefore ask the court not to apply that case against to your case, because it doesn't apply. Obviously, do not use words whose meanings you do not have a proper comprehension of, because there at that point you will not be able to ably defend what you're speaking to. The other thing I was asked to speak about is the ethical boundaries in advocacy writing, and I've broken it up in terms of our professional duty, the duty to the court, the duty to the client, the public, and the public at large. So what is our professional duty? As advocates, whilst we have a duty to the client, we have a duty not to distort facts or mislead the court to secure a favorable outcome, and that comes from our duty to the court. One of the duties we have to the court is that we are officers of court. So as a professional, we must be independent when presenting our client's case. and that includes avoiding distorting facts or misleading the court to secure a favorable outcome. I know in terms, when we talk about persuasive advocacy, people might think you must ensure a win. To persuade the court, you must ensure that you win. But winning does not mean you must go against the ethical requirements of our profession. So we must avoid distorting and misleading the court. Then we must exercise independent judgment that requires us to advise our clients objectively. Sometimes clients require us to do things which we can't do in our professional setting. So a client might require you probably not to disclose a piece of evidence that is relevant for the case, maybe because that piece of evidence is against their case. But because of our professional duty, we are required to disclose evidence that is relevant to the case. Or clients might require you to have the cases where lawyers have been involved in ensuring that some documents get off court files, for example, because you're trying to win a client's case. So in advocacy, in our advocacy role, in our advocacy writing, we must ensure that we are independent and we are able to advise our clients objectively without following everything our client wants us to do because they want to win. And then what's our duty to court? Our duty to court is that we must cite authorities accurately without omitting or manipulating context. In the desire to be persuasive advocates, sometimes you've found that some advocates cite cases and manipulate the context to divert the judge from the actual context of the case. So you find that the case is wrongly cited, or they manipulate the meaning or omit some parts of the case to justify. So our duty to court is to ensure that we cite cases accurately, give the full case, give the proper principle that the court in that case gave, and leave it to the court then to decide. There is a duty to disclose unfavorable authorities or facts that materially affect the case while fairly distinguishing them. That's a hard knuckle, but it's an ethical consideration for us advocates. Even where the authorities have unfavorable facts, if the authority is relevant, it's our duty to give it to the court because the court would need to look at it, but we could still distinguish it depending on the facts of our case. Then avoid frivolous and vexatious arguments that waste judicial time or undermine public confidence in justice. And I think I won't belabor that. The judge spoke to that when he was speaking about submissions. So whenever we are making arguments, we need to avoid frivolous and vexatious arguments. What's our duty to the client? We are required to represent our clients effectively and with zeal. However, that zeal should be within the bounds of the law. So as we do our work for the clients, as we pursue persuasive advocacy, it's important that we maintain our ethical code of conduct and not go overboard. We must present the client's case as strongly as the facts and the law allow without deception. I don't need to belabor that. We must ensure confidentiality of client's information at all times, and then avoid pursuing hopeless arguments that could harm the client's credibility. So it's important in our pursuit for persuasive advocacy to ensure that we comply with our duty to the client and ensure that we serve the clients well. What's our duty to the public and the administration of justice? Lawyers should ensure that written submissions or their cases promote fairness and access to justice, not delay or obstruction. And what are some of the causes of delay? Like I said, where you file a case which doesn't clearly show what the dispute is, at times you'll find that the other party then will have to ask you for further and better particulars, or the court itself will not understand your case and will take you back, or you'll start filing amendments, and in that process you're wasting court's time, there's delay, and it's not fair for access of justice. Our duty is transparency by presenting arguments honestly. I think I've already talked about our duty to be honest. And then public confidence in the impartiality and integrity of the legal system. We have a duty to ensure that there is impartiality and integrity in the legal system, and we can do that with presenting proper cases, with presenting accurate facts, with presenting accurate evidence without deception, and obviously presenting submissions that guide the court in terms of administration of justice and coming to a just and fair decision. So what's the place for AI in advocacy? Oh my God, the slides are sliding again. So what's a place for AI and advocacy? My Lord Justice Mubiru has already talked about the fact that AI is a tool that he advocates for us as lawyers to utilize, but we must use with caution. So for me today, I just wanted to share with you why we need to use them with caution. In my presentation, I have some cases where lawyers have been penalized for using fake case law because they were relying on AI. So in one of the cases, the High Court in UK told lawyers to stop misusing AI after the case law citations were found to be false. So the citations that were relied on by the lawyer who used AI were found to be false because those cases did not exist. So the court advised lawyers to avoid just using fake case law. So it means that as lawyers, as we use AI, we must double check. So when the case, for example, is highlighted by AI, as the lawyer, we must go through it and double check and confirm, is that the right case? Or if it's a legal provision, I've come across legal provisions on ChatGPT, but when you go to the text itself, it's actually not the provision that you expected to see. So it's very important to double check the provision. AI is very helpful because it will quickly give you the provisions, for example, or give you the cases for reference, but it's not enough for you to just get the cases and then dump them into your submissions, or the laws, the provisions of the law cited, and dump them into your cases. It's important as an advocate to be able to go through them, double check and verify. And as my Lord said, if you're known for citing wrong decisions or wrong cases, then the court will not rely on you. That affects your persuasive advocacy. Because as soon as you present your case, the court is already suspicious. So you will not be very convincing to the court with your submissions or with your presentation. From the beginning, from the pleadings, the court will be cautious from even your pleadings to double check and ensure that what you're speaking to is right. So as lawyers, AI is useful, but like we said, should be used with caution. Okay, and why should we use AI with caution? One of our professional conduct regulations requires us to not exploit our clients' shortcoming. The reason why our clients engage us is because we are the ones who have the knowledge that they require. We are the ones who can ably represent them. So once we only rely on AI, holistically rely on AI without double checking it, and then there are errors, then we are infringing Regulation 11 of the Professional Conduct Regulations, because we are not presenting a proper case for our client, but we're presenting fabricated cases or non-existent cases, using them to present the client's case, and then they are not helpful. Regulation 12 requires us to advise our clients diligently, and therefore it means that when we're advising our clients diligently, it means that we must advise them on the proper legal regime. So if we rely on fake citations we pick from AI without cross-checking them, then we are defaulting on our duty to our clients to advise them diligently. Okay, and then Regulation 17 requires an advocate to advise the court on matters within her special knowledge. And we actually have special knowledge in the law by virtue of our training. So when we only rely on AI-generated matters or cases, and we do not use our special knowledge in presentation, in distinguishing, in arguing those cases, in ensuring that the cases are correct or the provisions of the law are correct, which have been given to us by AI, then we are defaulting on our duty as advocates on our duty to the court. So in our advocacy, in our pursuit for persuasive advocacy, it's important to use the AI, but use it with caution. How best can we use this AI? In research. So AI can be used to identify relevant statutes. What are the applicable statutes, for example? What is the applicable case law and the precedents? Now, once those have been brought up, then as a lawyer, now you double check and see whether they are accurate. AI can be used in drafting. I think my Lord has already demonstrated to us that he uses it to come up with the initial draft. So we could use it as well to come up with the initial draft of what we are working on, and then fine-tune that draft as presented by AI. AI would also help in structuring our submissions in terms of headings, ensuring that it's chronological. So it can help us in presenting a chronological presentation. However, we must put in our part. And then it can also help us in terms of avoiding repetitions. Where there are repetitions, where there are spelling errors, AI is useful. As a lawyer, your eye may not catch some of those repetitions or inconsistencies in the pleadings or in the submissions that you've presented. But AI would be able to run through. You run through an AI check and then run through, and AI will be able to identify for you what has been repeated, what is inconsistent, where there are errors, and then it would be able to help you as a lawyer in terms of making your submissions look better. So I've come to the end of my presentation, and in summary, this is what we must look out for as lawyers in ensuring persuasive advocacy. Understand the facts of your case and the law of your case, and once you've understood that, then present it in the pleadings very well. Know your audience. My Lord said about knowing the judge and knowing the temperaments. So we must know our judge, and we must know the opponent, who is our opposite counsel on the other side. Knowing your audience also enables you to ably present your case. Let your pleadings, let your submissions be guided by pleadings. That was an error there. It should be let your submissions be guided by pleadings. Have your work well paragraphed and organized. Avoid ambiguity in your presentation. Choose precision over complexity. Have an appropriate and consistent theme and tone in the presentation from the beginning of your case at pleading stage, through the leading of evidence, and at submission stage. And then keep the reader engaged by using your active voice. So you can actually speak through writing. And that's the whole part about advocacy writing. So keep the reader engaged by using your active voice. I would like to thank you very much for listening to me. And if you have any questions, I would be welcome. I'll welcome them now. Thank you.
Thank you so much. The virtual audience, please show us some love. Are you on there? Thank you so much, Ms. Chalimpa. Thank you very much. Thank you very much for the love. Thank you. It was such a wonderful presentation. And I would like to note that when we came up with the legal writing masterclass, most of the people we contacted were referring us to people who draft in Parliament. Basically, I think the understanding of legal writing at LDC is legislative drafting. And yet we basically don't understand that whatever you're doing, even if you're writing an email, that is legal writing. You're writing an email you're drafting a notice of intention to sue, you're drafting pleadings, submissions, judgments, that's all legal writing. So I'm glad that we have a panel that really gets it, and each one of you has delved deeply into the section that was given to you. Thank you very much. I would go to the chat box. Carrara Victor says, thank you very much for the presentation, Council Olivia, and the depth despite the short time allocated. Thank you very much, Carrara. Okecha Nancy says, thank you for the great presentation. Thank you very much. Lydia Antono says, Council Olivia, thank you very much for the thoughtful presentation. What's your take on a scenario where, much as a matter is unpleaded, the parties on trial submit on it, and indeed each of them is given a chance to defend themselves, much as it may not have been in verbatim? Would you agree that it falls in the exception of where the court decides an unpleaded matter, where parties have been given an opportunity to present on the matter, as per the case of Sinba K Limited and 4 others versus UBC, Civil Appeal number 3 of 2014? Let me finish these comments while you think about your answer. Mr. Okuda says, good job, Advocate Olivia K. Matovu, in transversing the practical terrain of persuasive advocacy. Linda Gidudu says, absolutely, one needs to double check, especially with ChatGPT, otherwise it will cause embarrassment. I would allow you, Madam, to answer the question.
So, like you said, where parties have been given an opportunity by the court and both parties agree to submit on an issue, the court will then agree to give a decision on it. But the topic today is persuasive advocacy and preparation for a proper case. So that's in circumstances where both parties have agreed, and the court, in the interest of justice, will make an exception and allow both parties to make a presentation on a matter that wasn't pleaded. But we must be alive to the fact that advocacy starts at pleading stage, and that's why I would not encourage that we wait for presentations before the court and at submissions level to bring up a matter, because you would not have given the party ample notice to present, let's say, the evidence that would be required or the defense. So there would be certain exceptions, but that's rare. Sorry about that technical glitch. Yes, so today's conversation is meant to guide us in terms of how do we make better presentations in preparation for in representing our clients. So the ad hoc presentation of issues or of points during the hearing after pleadings have been closed and evidence closed is not advisable. There might be exceptional cases where the court, in the interest of justice, might allow both parties, and parties consent to that. However, it's not a general rule. Many times the party will object, and they'll be in their right state to object to that, because it would not be fair, it would be prejudicial probably to their case and the client's case, and it would be unfair to be an ambush of sorts. So it's important that we should be ready from the start. That's what my take is on that. Thank you.
Thank you very much. And the theme is master commercial drafting before it masters you. Don't wait for something to come up at the end when you can prepare for it and ably represent your client. I would like to just go through some of the I had asked the virtual audience to say hello and tell us where they are coming from, they are joining from, and I would like to read those before we delve into the next comment, if it's there. Mohomuza Bashir said good morning. Barbara Road said good morning. She's from the Auditor General's office. Linda Gidudu said good morning. Chan Godfrey Masembe said good morning. Piloya Dora Lillian said good morning. Isaac Kawoya said good morning. He is from Stanbic Bank Uganda Limited. Thank you for joining us. Kafero Alexander said good morning from Kafero Alexander, B&A Advocates in Kampala. Lamunu Sharon Topista also said good morning from Redeem International. Sia Aziz Swale from Nabende Advocates. Thank you all for joining us. And I hope you are getting value for money and your time. If there are no other questions, are there any other questions for Councillor Olivia or comments for that matter? Oh, yeah, well, Lydia, you asked about, she wanted Justice Mobiro's take on the same question. But like we had said, you're preparing them to ably prepare for the case and handle all the matters therein. Justice Mobiro, would you like to say something about it?
Thank you very much for the question and for the presentation, Olivia. I'll speak from experience of when that is likely to happen. You know, when you present a case, it's a question of perspective. Events happen, you analyze them and identify what you think is the issue and present your case to court as a plaintiff. Then the defense comes up with its own perspective of what they believe is a defense to your case and present it in their pleadings. Then you have a third mind, the mind of the judicial officer, who considers both perspectives.
Your microphone is off.
Sorry?
Yeah, are they saying your microphone is off? Can you hear Justice Mobiro? The virtual audience, please indicate if you can hear him.
Okay.
Okay.
Yeah, as I was explaining, you have two perspectives of an occurrence, the plaintiff's perspective and the defense perspective, and in between, the judicial perspective. So you might come up with a case believing the issues to be X. The defense comes up with its own version, believing the issues to be Y. And the trial begins with that understanding. But as you proceed during the trial, you realize evidence is coming in that changes the perspectives of both parties and persuades the court to have a different look at the dispute. Then you recharacterize the issues at that stage. And then you find yourself, if the parties agree, you don't need to go back to amending the pleadings because now you've agreed the issues that have emerged should also be taken into account, and evidence proceeds on that was not part of the original pleadings but is necessary in order to do justice between the parties. So in those kinds of situations, you may have unpleaded matters by consent of both parties becoming issues for determination in the same trial in order to avoid wasting time in amendments or deferring them to other litigation, a multiplicity of litigation over the same issue. So in order to avoid those circumstances, the practical solution is to allow in the evidence and make a decision on that point. So sometimes it is arising out of laxity at the time of the initial pleadings, but on other occasions it is because of the natural tendency to have different perspectives of the case, which keeps on evolving as the evidence comes in. Whichever way it is, the court is required to do justice to the case and the parties without sticking too much to the course of pleadings, the requirements of pleadings. But it is not an excuse for inaccuracies in pleadings. Strive to present your case in the best way you understand it, but allowing for a different perspective to emerge if it is necessary. I thank you.
Thank you so much, Your Lordship. Ms. Lydia Antono, I hope your question has been answered. Before we delve into the next presentation, Mr. Chirunda, I hope you're on standby. I would like to tell you about Legal Forte, a newsletter that gives a platform to lawyers to write, do advocacy, tell their stories, and a voice to basically talk about the world in the lens or from the lens of a lawyer. And we are calling for articles, and we're going to share the email address to which you can share your articles. We would like to basically encourage you people to write, and it doesn't necessarily have to be legal proceedings. You can also write about your experiences in the legal space, because all that counts. Now, I would like to delve into Mr. Chirunda's presentation. And when we first contacted Mr. Chirunda, we had a long list of things we wanted him to tackle. It's already deep enough. And so for this one, we need to just talk about clarity, risk allocation, commercial sensibility of contracts. And for a moment, he fried my brain with a lot of things that I didn't understand. Mr. Chirunda, I would like for you to come in and make your presentation about the anatomy of clear contracts, the mastering the art of risk balance, how these lawyers can spot, allocate, and negotiate risk without killing the deal of your client, avoiding legal overkill that hinders commercial relationships, anticipating dispute scenarios and exit clauses. And we hope by the end of it, the advocates on call will be able to draft like a deal maker and not robots. Mr. Chirunda, you're most welcome. The mic is yours.
Thank you very much, Zubeda. I hope you can hear me.
We can.
Thank you. First of all, many thanks to my Lord Justice Mubiru for such an erudite presentation. After so many years in litigation, I very quickly messaged my team and said, now we finally have a masterclass on how to write submissions. My Lord, as one of your students, we continue to learn. I was in the firm for which you were one of the tutorial, I think you were our tutorial, whatever we called them at the time, I think associate partners at LDC. And 20 years later, my Lord, we continue to remain grateful. I am grateful to the ULS and Zubeda from the Muslim Arbitration Mediation Center for inviting me, and to my colleague, dear friend and classmate Olivia. All these years later, it continues to remain an everlasting joy to share platforms with you. Zubeda asked me to speak about, and she is right, when she contacted me, we agreed on two things. The first is that she was asking me to talk about too much, and I thought that sometimes too much information leaves us with less knowledge. And so I wanted to pick a few things such that maybe, hopefully, we can take away a few lessons that we can apply. I hope that if nobody creates the opportunity, my Lord Justice Mubiru will allow me to press the point about a practical session on drafting submissions. And I think that a similar view could be taken on drafting contracts. We litigate essentially a lot of, most of our cases in the commercial court and in the land division are really based on contract. Apart from the criminal division, the family division, where we're dealing with other affairs of life, a lot of what we do in the two busiest divisions, at least in the High Court in Kampala, and I don't know what the statistics are elsewhere, but when I did matters in Jinja and Kamuli in the East many years ago, the bulk there was land. And a good number of land disputes were really based on a contract of some kind. And so I think that stepping away from the advocacy side that my Lord and my friend and colleague Olivia have been talking about and coming back to contracts is very helpful. I also, Zubeda forgot to mention, and I think that housekeeping, I should be probably upfront. Unlike my fellow panelists, I told Zubeda specifically that unless she held two guns to my head and promised to kill me twice over, I would not prepare a PowerPoint presentation because I have found that I speak, and at least some people have said to me that I speak clearly and better without the presentations. And for that, I must apologize in advance for those who prefer to look at slides. But I will try my best to convey with as much clarity as I can 5 major areas of the presentation. The first is just to supplement very, very, very high level on Justice Mubiru's excellent and insightful presentation on principles of all legal writing, whether it's contracts or generally submissions. The second would then be to go into the anatomy of a contract and to think about, the goal is to help for all of us to think through a contract in a structured way. Many times when we advise clients, those of us who have advised borrowers, for instance, when they come to us and they are in trouble with financial institutions, I always tell people that when borrowers are going to the bank or to a lender, they read the contract from the beginning to the end. When they come to me for counsel, I read it from the end to the beginning, because they are looking at what are the commercial terms, what is the amount disbursed, what's the interest, what's the cost of the loan, and then they'll just browse and sort of depend on the lawyer to read the rest. That's a big mistake. We, on the other hand, will start from the end to say, is there, do I go to court, do I go to arbitration? What are my chances? Was there an indemnity here or not? Those are the clauses at the back of the contract. It helps, therefore, for a drafter to think through a contract in a structured manner, and for that we'll deal with the anatomy of a contract. And then we'll go to principles of legal drafting that are more specific to contracts than to submissions. Then we'll touch on risk allocation, and finally we'll talk about exits. So a lot of this will sound general, because if you go to specific fields of law, you will have specific rules that apply there. And so I think that general principles would be a good place to start. And in keeping with that, a few major points. Every drafter of a contract, I think, would do well in thinking about, first of all, first-year basic contract law. It sounds simple, but it's really important. What is a contract? There has to be an offer, there has to be acceptance, there has to be an intention to create legal relations. This is one of the areas where I find many challenges with people who litigate MOUs, because the debate remains, is an MOU a binding contract or not? I think that if the tenets are there, then it will become a contract regardless of what you call it. But if certain tenets are missing, then was there a contract in the first place? So this point about intention to create legal relations is really critical. What was the intention of the parties? Do they have the capacity? Is this something they can contract about? And so on and so forth. Now, away from the generalities, every field of law, every industry specialization will then have specific points that one would do well to understand. The way that we would negotiate a simple land sale agreement would have certain similarities, but certainly have main differences between how you would negotiate a production sharing agreement for oil and gas. And yet, if you're thinking about tax obligations, there will be tax obligations in those two contracts. But where do you allocate, where do you put the tax burden and things like that? That's another issue. So thinking about contracts generally in terms of what is a contract, what is the anatomy of the contract, what do I need to make sure at the bare minimum is in the document I'm going to draft at the back of my mind would be a good starting point. The second starting point is, are there industry specifics and standards that I should be looking at? If I'm negotiating, I see some bankers on the call. I see Mrs. Wali Mukubo, I see Chris Engola, and these bankers would tell us that if I'm negotiating an intercreditor agreement, there will definitely be need to think about a cross default clause. What that clause looks like in the industry might not differ much in terms of the contract. Now, if you find yourself in a multiple lender situation and there was no intercreditor, there was no cross default, you can imagine what will happen on the dispute side. And so the point I'm making here is that when you are dealing with a specific industry, it would help to at least know the basics. Now, upfront, I will point out a mistake that I think we make often as counsel. You get a big client, or you get a client with one of your big clients has a specific issue and they're looking to write a contract. None of us is a master of all fields of law. And I think it is a big mistake to assume that you understand every contract that can be written. You lose nothing calling a colleague who is better than you in a certain field and seeking help or finding out a way to align and learning from them. I think that it helps a great deal and would save us a lot, especially in terms of thinking about industry specifics. So the third point then would be, what is the law? Because when we fight about this contract, in the end, we will go back to what Justice Muri just said when he was responding to the question to Olivia, that there is your version, my version, and then there is the version the judge must take. And the judge is going to say, that's what you all agreed. Was it legal? And therein lies the problem. If at the time of writing the contract, none of us thought about whether this contract would be acceptable in law, then we are going to have to defer to one of Justice Mugiru's excellent decisions on public policy and say, but what you both did, doesn't pass Uganda's public policy. And that therefore creates a dispute. These general principles, as routine and obvious as they might sound, I have found are actually a starting point for many disputes that I've had the privilege of litigating. Because at the point of writing the contract, I have often argued that disputes don't start the day someone declares the dispute. Disputes start the day the contract wasn't clearly written. Because some disputes really are just arguments waiting to happen, and they can be avoided. So starting from there, I think that those three are major points to think about. What is a contract? What are the rules governing this specific contract I am writing? As a lawyer who practices in the tech space, oftentimes I have a client sitting on the other side of a tech deal, and the person decides to originate the contract on who's doing a deal with my tech client. And when I read it, I can see that the person who wrote it does not have a depth of understanding on technology contracts because they differ in their nature from ordinary contracts. And if I read that, I have two options. I can redraft the contract and bring it back to where it should be, or I can work with what you have. What option am I going to pick? I would say that for the sake of all of our clients, it is helpful, even where we detect that there is a mismatch in skill and ability, to just bring the parties together. How we do that skillfully, patiently, and clearly is part of what I think Justice Mugiru said in one of his comments when he talked about the respect for one another and respect for seniority. I tell the young lawyers who work with me that seniority, by the way, is, and I agree entirely with Justice Mugiru's comment on this point. Seniority does not exist by mistake. We all learned from somebody, and we would do well to learn from other people, because then we avoid the mistakes that they made. And when I was a young lawyer and they said to me, your turn to be senior will come, it always felt like, no, you all are just protecting your turf. But now when people find me and they say, oh, you're senior, you look back and you think, man, we've come a long way. But I digress. So generally speaking, that's where I wanted to start, which then brings us to the principles for all legal writing. There are some principles that I have found to be useful to me regardless of what I am writing, and I will just run through them briefly. And they fall under three major categories. The first principle is frame your thoughts. Whatever you're going to talk about, frame your thoughts. And under framing my thoughts, I usually do 3 or 4 things. The first thing is, I think to myself, what exactly do I want to say? And then I will plan. That's the first thing I will do. And I will usually bullet that on a piece of paper and say, what I want to say is ta, 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 ta. At the point, one good point to do this is when you are taking instructions to write an agreement. What exactly is the client asking you to write? And so that then translates in your mind to what are you going to say? And then plan the drafting project. What do I want to focus on and how do I want to draft it? If I am drafting a 5-page contract and I am negotiating a simple land sale agreement, then I know that I am going to talk about payment terms, I am going to talk about tax obligations, I am going to talk about vacant possession, I am going to talk about indemnities and warranties, I am going to talk about commissions, which are usually the sticky points. But which one do I want to write first and how do I focus on each of them? Planning helps to make sure that you're not missing any vital points. Because if you focus too much on the tax clause and don't think about commissions, then you're going to have brokers fighting at your office. If you focus too much on commissions and don't think about tax provisions, then perfection will become complicated because the parties are arguing about whose duty is it to pay the stamp duty for this piece of land. Now you can imagine a person who is doing all land sale agreements, 50-60% might look the same. But think about a land sale agreement for a plot of land in Nigeria. Maybe Nigeria is a bad example. It won't drive the point home. Think about a plot of land in Namusera, for instance, a distance from the CBD, and think about a plot of land in Kololo. These documents might both be 5 pages. The tax burden differs. So maximum efficiency and planning the writing project will help to make sure that each point is getting as much attention as it deserves. And then order the material or order clauses in logical sequence, because that logical sequence will help us to think through the logic and rationale of the deal. And then after that, it is very helpful, and this cuts across submissions as well as agreements, to divide the document into sections and break it down into smaller parts. And when I was younger, I always thought the more complex the agreement, the longer the agreement, the more complex, the more beautiful. And in part on this, I will blame my first boss. When I just came back from school many years ago, my first boss said to me, "We need you to write an agreement," and the value of the transaction was $10 million. The year was 2007, I believe, and $10 million then, as now, was a lot of money. So I went and I used a short form template, and we'll talk about templates briefly. And then I came back and he said, "Robert, your draft is excellent. Only one problem. It doesn't weigh $10 million. Go and use the long form." We ended up with a 60-page contract. Now, do I still subscribe to that view? I will not write 60 pages if I can write 10. But in doing so, dividing the document helps me to make sure that I am saying everything I need to say in as much clarity as I can. And to be clear, there will be documents that need to be 100 pages. There is no other way to write you cannot write a production sharing agreement in 10 pages. It just won't be practical. You cannot write an intercreditor agreement in 5 pages. You probably can, but I think you will leave a lot to chance. So think through, what document do you need? How are you organizing your thoughts? How long should your document be? Planning, framing your thoughts. After that, I tend to think about phrasing my sentences. Phrasing sentences is a critical point, and this one has a few rules to go with it. Number 1, omit needless words. Don't say he hastened to arrive if you can say he came. Juxtapose does not mean compare in certain instances. A couple means 2. These things seem obvious, but people say, "We wrote a couple of sentences," when they mean 5 sentences. A couple, at least so far as I'm aware, means 2. But point number 1, omit needless words. Number 2, keep your average sentence length within minimum containable text. Depending on which author you read, the recommended length is either between 14 and maximum, if your sentence must be very long, 20 words. Any sentence longer than 20 words either needs to be really carefully punctuated, or is going to become winding and will lose meaning. The simple question is, when you're writing this sentence, what are you trying to say? Say exactly that. Don't use words you don't need to use. At my office, we call it word economy. The third point is, keep the subject, the verb, and the object together towards the beginning of the sentence. Now, this is where, if we were in a practical session, we're going to English writing and phrasing words. And sometimes we are saying the same thing more than once. Why? Pick the words, the verbs, and the phrases that are needed. Also, we like to use certain phrases that can complicate unnecessary wording, and we'll come to this under legal drafting. For the avoidance of doubt. That means there's doubt already. So what is it that you need to say to avoid using those words? Say that. And then use parallel phrasing for parallel ideas. If you are phrasing the same thing over and over, then don't phrase it differently. You just create unnecessary confusion. Then there is the use of negatives, double negatives. I think the commonest double negative, or maybe the easiest example in Ugandan law, is Article 126(2)(a). Substantive justice shall not be administered without undue regard. Substantive justice shall be administered without undue regard. Maybe the framers could have just written, substantive justice shall be administered without regard to technicalities. But, or they could have found another way to word it. Did they really have to use a double negative? The jury is still out on that one. And then ultimately, the third principle there is choose your word. Learn to detest any jargon that can be simplified. Why do we like to say herein after, otherwise referred to as? Can't we say that in one sentence? Can't we just use parentheses to say that? Hereafter. Because if I say Standard Chartered Bank, hereafter, Standard Chartered. And then I say Standard Chartered Bank, herein after referred to in every clause as, I could have said Standard Chartered Bank or Standard Chartered Bank or Standard Chartered. I could have said Standard Chartered Bank or the bracket or the lender. So if I want to use jargon, I think when we were trained and when we read older precedents, we were made to believe that the more complex the jargon, the neater the text. I think that's not true. Also, use strong, precise verbs. Minimize the use of words like is, are, was, were. Those words, as simple and basic as they seem, can complicate very, very simple sentences. Simplify word phrases. Many times we use the word of in places where we could have avoided it, and you would be shocked how much meaning that changes. The example I like to use, and by the way, the other one is punctuation. Mind your punctuation. The example I like to use on that is, no man is an island unto himself, a phrase that we all know. No man is an island unto himself. If I put a comma after no, the meaning changes. Now, that's the same thing as thinking through everything I am writing should be speakable. If I was to say the clause back to you, would it make sense to you? And if I'm referring to, if I'm writing a document, here is another really common one. Do I refer to the lender? Do I refer to Standard Chartered Bank? And I'm using this example, I mean no disrespect to the bank, only because I saw some friends of mine who are there on the call, so they are easy prey. If I say Standard Chartered Bank hereafter the lender, and I say Standard Bank hereafter Standard Chartered, which is better? The preferred convention by some drafters is that if you can, refer to people and companies by name, not by other appendages, because that simplifies, especially where you're going to end up in a situation with multiple parties, multiple players in this transaction. Uganda's economy is getting even more sophisticated. And if you think about the number of contracts, some transactions will have contracts running in the hundreds of pages, in the tens of documents. And if you have to weave these documents together and you're referring to a party by different words in different contracts, that's just going to cause confusion. So when you can, refer to parties by name. Also, don't habitually use parenthetical shorthand names or brackets unless you really need them. But if you don't need them, then avoid them. Which brings us to, so those would be the starting point in terms of general legal writing, framing my thoughts, framing my sentences, choosing my words, which then brings us to the anatomy of a contract. Generally speaking, I have found that a contract has 4 major pillars. The first part is definitions. Any word that I am going to repeat over and over and over, I'm probably better off defining. Now, the question is, where do I put my definitions? How many definitions do I need? I've seen shareholders' agreements that have definitions that are 4 pages long. Why? We are talking about shares in a company that has 5 shareholders or 3 shareholders. Must the definitions be 4 pages long? You can as well have them down to 1 page. If you have many definitions, the preference is put them at the back of the contract, because then it's easier to focus on the clauses of the contract themselves. Even location of the clauses matters. And then you will go down to the prime clauses, or what sometimes I like to refer to as the commercial terms, which is, what is the deal? What is the contract? What are these parties actually agreeing on? I am agreeing to sell to you a piece of land located at block this, plot that, land at Kungu. That is the deal. You will pay me 100 million shillings for this piece of land. You will pay it to me in the following installments. Write that as clearly as possible. Now, obviously, when you go to specialized areas, and here again, I will pick on oil and gas, I will pick on banking, I will pick on tech contracts. What is the commercial sense of the understanding may require far more careful drafting than we are used to in a simple land sale agreement. So again, I will keep drawing the distinction, and even on definitions, by the way, I will keep drawing the distinction between simple contracts and complex industry-specific documents. Where the document requires that level of complexity and you have so much information to put it in, write it in nonetheless, but write it clearly. If you look at Uganda's production sharing agreements, for instance, the commercial terms in terms of how much oil Uganda will get, and anyone who's looking into the oil and gas industry will do well to look at the older production sharing agreements and the newer ones. And the current model agreement, I believe, has simplified that. You have a tiered clause, but the tiered clause in such simple English that it's easy to understand. So if the subject matter is complicated, is there a way to break it down in such a way that anyone looking at it does not have to be an expert in oil and gas? They can understand it by just being a simple commercial lawyer. So those are the prime clauses. Then you have the general clauses, which is where you have your reps and warranties, your indemnities, and those contracts that basically give cover to the commercial understanding. In the commercial understanding, we are making promises. In the general clauses, we are reinforcing those premises. The principle here is good fences make good neighbors. And we are saying that if I am saying to you that I will pay you 100 million in a prime clause, then I will come to the general clause and I will say, I can promise you that I have the ability. I am confirming that I have the ability to pay you 100 million. And so I represent to you. And that representation is enforceable. And if that representation gives way, if I fail in honoring that obligation, then what is going to happen? I give you an indemnity. And I say, look, if you go and incur costs because I failed to pay you 100 million, which I promised you that I could, then I will pay you for the loss. I will indemnify you. I will make you whole for whatever loss that you suffered because of my inability to keep my commitment. And so ordering these clauses in a logical way helps us to think through the logic of the transaction clearly. And then after general clauses, we have the so-called boilerplate clauses, the ones that many of us like to copy and paste from one document to the other. Dispute resolution, time is of the essence, and that is where many things go wrong. I would encourage a few points on this anatomy. Number one, what is the deal? Number two, what is the law? Number three, read each clause and each word carefully. One time, a person very near and dear to me was advising on a contract, and on page 1 is where the problem was. This borrower had gone to a private equity firm to invest in this business. And the private equity firm was represented by Katende Sempegwa. And they said to the borrower, please go and get a lawyer. Please go get a lawyer. Please go get a lawyer. And the borrower, I think for whatever reason, just thought, these people are just being obstinate. And they kept insisting, please go and get a lawyer. They went to one of the other big firms, which for discussion we shall not mention. And when they got there, the associate who, this was many years ago, maybe 10 years ago, the associate whom they gave this thick contract from Katende Sempegwa said, this thing is too long. My boss has given it to me, and I think we are misadvising the client, which is how I got to know because I wasn't working at this other firm. What do you think would be the, and page 1 is where the problem was. The contract said, we commit to give you up to $1 million if you give us so much equity. The senior person in the firm said, I don't see what's wrong with this contract. They're going to give the person $1 million, but is that what the sentence actually said? I've been in a similar situation where our client came and said, look, and I think Zubeda liked this example and I gave it to her, so I'll just use it here as well. The client came and said, I want to give away 40% of the shareholding in my company. I want to give it away in exchange for $120,000. I want to give it to so-and-so. Please draft the document. We asked the client, how much do you think your company is worth? And the client said, the company is worth $5 million right now. In the next 5 years, $20 million. And we said, you are giving away 40% of $5 million for $120,000. That doesn't make commercial sense. And he kept going on by saying something very simple. 40% of 0 equals 0. Give the person 40%. What ended up happening was my colleague who was working on the transaction wrote, we will give you up to 40% because in negotiation it became clear that the other person never intended to release $120,000. And so the clause then became, we'll give you up to 40% for all the amounts you release, and please release this amount in installments, because we were sure that this person will never put down 120,000 in a bullet payment. I think 2 installments in at 40,000, the person said, I'm not investing anymore, give me my 40%. The fallback was up to. The other person did have a lawyer. So read each word, read each sentence carefully. Avoid the so-called midnight clauses. It is unwise to slide a clause, or what they call the champagne clauses. Everyone is so happy the commercial terms have come together. We've been negotiating for 7 months and we finally have arrived. And then someone says, by the way, I noticed there is no indemnity. Oh no, let's just just throw in a clause, the so-called midnight clause, when the champagne was coming out of wherever it was, and they threw in a clause, and then the dispute happens and nobody is thinking about, wait, we chose to arbitrate in China. How? How did we get here? It is unwise to draft that way. That's really the anatomy, and we'll go down into a little more detail just briefly. But let's now talk about general principles for legal drafting that will appear more relevant even in contracts more than in disputes. And here there's about 7 to 10 principles that I like to emphasize. Number 1, draft for the ordinary reader, not a mythical judge, not a complex industry practitioner. Is and remains the best kind of English. If it can be simplified, it should not be in your document. If you can say it in plain English, do not use complex legal jargon. If there is a plain dictionary word that you can use, please use that. I can come and say tax gross up, and I expect that a banker, a lender, anyone will understand the tax gross up. Or I can come and say, at all times, the tax liability in this contract shall rest upon. Can you hear me? I think I see my video. It's having a bit of an issue. Zubeda, would you confirm that you can still hear me?
We can hear you.
Okay, great. Thank you. Now, I was saying that in the end, it is that complex jargon that will lead to disputes that could have been avoided. Number 2, organize provisions in order of descending importance. Now, of course, the argument is that each provision is important. But I usually like to ask myself, what is the one provision the parties might fight about the most? And if I am writing a clause that has many points in it, then I will break it down. I will not use provisos. That's the other principle. Please do not use provisos. If you are using a proviso, there is no agreement. If you are saying, I will do this provided that, then the parties haven't yet reached a clear understanding of what they're trying to achieve. If you think about it deeply, it just means that one party is still holding back. Then you come and say, we will do this and this and this. In exchange, you will do this and that and that. Instead of, I will do this provided that you do this and that and that. We are still saying the same thing. I will give you 100 million provided that the land is vacant. Why not say, I will give you 100 million, you will give me vacant possession? Because that's what we are trying to achieve. So I have found that when you simply avoid what we used to call clever drafting, you simplify matters. Now, we like the word shall, but do we need it? Because now we have a lot of jurisprudence that says sometimes shall can mean may. So because I know that, do I really want to end up before a judge arguing about was the intended meaning here shall or was it may? Is there a clearer way I can say that? So while I am thinking through all of these things, I am thinking about, number 1, can the person who trained me on drafting contracts 20 years ago, a gentleman, and I will give him his flowers because he still lives, a gentleman called Mr. Kakembo Katende used to say, if my grandmother can't understand it, you are wasting my time. and it's a so-called babushka rule. Draft like you were drafting for your grandmother. Now, because we have much younger people on the call, some grandmothers now are in their mid to late 40s, in their early 60s, in the computer generation, so maybe the phrase doesn't apply anymore. But let's use draft like you were drafting for a 4-year-old. If a 4-year-old can't understand it, it is too complicated. Simplify it. Minimize definitions. And if you have more than a few, as I said earlier, put them at the back. Break down enumerations, if you can, into sub-paragraphs, because then it is readable, it is much clearer. Don't use provisos. Replace and/or wherever it appears. We like to say and/or, but that I think that is actually not good drafting. If you want it to be inclusive, use and. If you want to be exclusive, use or, but don't use, because it can't be both inclusive and exclusive at the same time. You can't say the lender and or, because I am either the lender or I am not. I am either the borrower or I am not. So and/or, I would say delete it in every single document that you ever write. You are saying one of those two things. Either you are being inclusive or you are being exclusive. Always prefer singular to plural every single time. Where if you can number and denote, if you're using numbers, if you're using amounts, 100 million Uganda shillings. I think that the correct English is Uganda shillings 100 million, but the bankers might disagree. If there is the slightest possibility of ambiguity, please use both. Put the figure, put the words, such that there's clarity. It might appear repetitive, but I think it helps us to emphasize. Which takes us, I see that time isn't our best ally, so which takes us to risk allocation. There is a very simple cardinal rule here that we use at the firm where I'm privileged to work. And the rule is this: you are in a room to make the deal, not to break it. If your wording is going to result in the breaking of a deal, please rewrite it. And I'm trying to avoid confusing drafting with negotiation. And I will use a few examples here. And again, here I will go back to what is the law. The year is 2007. I am a rookie fresh from my first LLM, and I've been handed this contract which involves the central bank, and we are negotiating with an American law firm. American fund, which has lawyers in New York and in London. Obviously, we are outmatched. We send them the draft, they send it back with a price adjustment clause, and the price adjustment clause is a formula. It is not wording. For those of you who are familiar with the energy sector, you know that the Umeme tariff, the tariff on which, why many people don't know this, but if you buy units on Yaka, sometimes this month you will spend 100,000 shillings and get 100 units. Next month, spend 100,000 shillings, you get 87 units. The common man's interpretation is they are cheating us. They gave me less units. What many people don't know is that's because the tariff is a formula, and the number of units are determined by a formula, which is factoring in so many complications: the exchange rate, the amount of energy produced in that window, and so on and so forth. I had no idea how to read this calculus formula. My boss says, you're the drafter, figure it out. What was the simple thing to do? It was to go and say, what is the mischief? The mischief is they need to have a way to move the price down if the asset turns out to be lower in value. Simple. Okay, why don't we just say that? So we took out the formula and we came and said, created a framework instead, which said, you will have a 90-day window to do your detailed due diligence. Every time you find something that reduces the value of the asset you bought, put it in a basket. And if the amount reaches the price you paid, cancel the agreement. Take back your purchase price. If, on the other hand, you reach day 91 and you have no need to revisit the price, the assumption is you got the value you paid for. So number one, make the deal. Don't let complexity kill the deal. But number two, and in that example also lies a really critical principle. Good drafters focus on joint value creation and joint value maximization. I want you to get a fair amount of value for what you paid for. I don't want my client to lose. There is a temptation here to say that I will protect my client. That deal is going to fall apart because somebody is going to leave unhappy. The best case scenario is either create joint value or maximize the value you have jointly. And one way to do that might be scenarios with clauses that interlink with each other, which is what them down into small bite-sized chunks will always be helpful. Now, there is another one here. Do you propose a compromise? Do you go for what is fair, or do you go for what is the most practical option for you? There are varying schools of thought on this. One school is draft what you believe is fair. I think the problem with that is that it is subjective. What is fair to you might not be fair to me. On the other hand, draft what you believe is the most practical option is a helpful tool. The way I do it is when I am faced with a scenario, you give me a clause that I think doesn't work for my client. I will not say it doesn't work. I will come and say, this clause doesn't work because 1, 2, 3, 4. Another way to go about it is A, B, C, because in doing so, this is what is in it for you, this is what is in it for me. There is no point in trying to be clever over the other side, because when you end up in a court of law, none of you will be clever. So the point is, be as transparent and ask yourselves, what are we trying to achieve? Let's write exactly that. And if the original version doesn't work for me, it doesn't help to simply turn around and say it doesn't work, delete the clause. What's the impact of deleting that clause? If we delete the clause, do we leave things unclear, so unclear that that will be the basis for the dispute? Good drafters anticipate and avoid disputes, but we'll come to that very, very shortly. So I would say, number one, make the deal, don't break it. Number two, create or maximize joint value. Number three, good fences make good neighbors. Number four, at the end of the day, seek alternatives and compromise. Sometimes I've been privileged to be in situations that were really complex. And the first principle that I have found to break the ice, even when my client is at a significant disadvantage, to say, the first question we must answer is there a deal here? It may not look like the deal I want or the deal that you want, but is there a deal here that serves both parties without leading them to a dispute? You would be shocked at how much flexibility that would unlock if you walk into a transaction with that mindset. One of the mistakes we make is that we come with a closed mindset and we must get, it is my deal or the highway. Definitely, at some point, somebody is going to take the highway. Then you are breaking, you're not making a deal. Which leads us to exit options. Here, I would perhaps just stress three principles. Number one, be practical. At the end of the day, we all want the deal to work. Sometimes deals fail. And I think the best example that I have had used in negotiation is the Cold War. Mikhail Gorbachev is hosting Reagan, President Reagan in Russia. And President Reagan is saying, Gorbachev says, I think we have reached a good understanding. And the clause was, we'll send in nuclear inspectors. And Reagan insists on it last minute and says, so Gorbachev is saying, that was you pressed the point too hard, and President Reagan says, we are Americans. We trust but verify. There is a healthy amount of suspicion that every drafter must have. And so prepare for the day that things might go wrong, but be practical. Number one, what option will serve you better? Is it the courts or is it arbitration? Do you want to mediate or do you want to go straight to the dispute? Because if you declare a dispute, there's a very good chance at that point the relationship is over. Number two, if you go arbitration, will your client meet the cost? Will your client manage the processes? Are you technical enough to understand what happens? I have seen, as a litigator and also as an arbitrator and a practitioner in arbitration, that when I have been on opposite sides of people who have no training in arbitration, I can see the disadvantage. And so I would encourage anyone on the call who is engaged in disputes, please get some training in arbitration. It really is not a waste of time or money. But also, I have litigated, and I remember, since his lordship is with us, maybe I'll use this example. I remember going to his court at the commercial division when he was still head and arguing most forcefully for a stay of proceedings. And we lost. And in his ruling, however, he did give us a phrase that I have enjoyed citing every chance I get. And the reason why he denied us a stay of proceedings was he said it is more practical to retry the dispute in the High Court than to go to the Court of Appeal. And this was about setting aside a judgment. And the sentence I like from the decision is, it is the lived reality of our court system that appeals take too long. That is a lived reality. So do I want to expose my client to that lived reality or not? I think about that when I am thinking about exit options. When I am drafting arbitration clauses as one of the options that I actually like, something as simple as, where do we arbitrate? Now, it sounds simple. Everyone likes to say London. But why London? I was once negotiating a contract where the opposite party was insisting we have to arbitrate in China, at the Chinese Arbitration Center, where Chief Justice Cartwright is a member. And by the way, in doing so, the seat must be China. I told my client, there's no way you would agree to that clause. Forget it. Getting a Chinese visa takes forever. No one understands Chinese on the team. Why would I put you in such a situation? And the client was saying, is that a big deal? There's a temptation to assume that disputes will not arise in a contract. I think that a good drafter should always assume that the best marriages can end up in a divorce. And when that happens, there should be enough rules in the document to guide the parties with as little friction as possible. So draft well, anticipate the dispute, that a dispute will occur, and be practical about how you draft. Zubeda, I don't know if I am able to share my screen. There is a clause I wanted to use as an example. If I try to send a sharing request and you let me share a clause, I think this clause would be a good example of many of the things I have talked about. Zubeda, can you see my request?
Yes, it has been allowed.
Okay. And I am sharing a clause. Can you see it?
Yes, we can see it.
So this is an arbitration clause. The first time I wrote an arbitration clause, it was 3 pages long. First time in my career ever. When I write arbitration clauses now, I prefer that they are not longer than this. And I have used this clause many times over. Let's just run through it together and see. First of all, you'll notice that it has a specific heading, arbitration. It doesn't say disputes. It doesn't say dispute resolution. It says arbitration. And then its wording is broken down into A, B, C, D. And each of those has a specific objective it is seeking to achieve. Number 3, you will notice that whoever formatted this agreement left enough white space. That's another point I forgot to mention. When you can leave white space, because it's easy on the eyes, it forces people to read the document. It's easier to read. There is a theory we like to use at our firm, which is, imagine the reader of your document has a mug of coffee. One of 3 things will happen. Coffee lovers are really obsessive over their coffee. If they are drinking their coffee too fast, your document is boring. If they are drinking it too slowly, your document is too complicated. By the time they put down their coffee mug, it's empty. There should be 3 in the document. That's the rhythm you want to achieve. Now, if you think about this clause, any dispute, claim, difference, or controversy arising out of or relating to or having any connection with this agreement, That really covers anything that might relate to this transaction, including any dispute as to its existence, validity, interpretation, performance, breach or termination, or the consequence of its nullity, and any dispute relating to any non-contractual obligations arising out of or in connection with it, brackets, for the purpose of this clause, a dispute. Notice this, those brackets could have been a definition in the definition section. This agreement is 110 pages long. As you can see, this is at page 86. But to avoid a further definition, someone has just come and used parentheses in the clause and then said shall be referred to and finally resolved by arbitration under the ICC arbitration rules. For the purpose of this clause, the rules. That's another definition that was avoided in the definition section. If you take that paragraph alone, 1, it is more than 20 words. But 2, think about where every comma is placed. Any dispute, claim, difference or controversy arising out of, relating to or having. Notice this, the use of the word or. One of the mistakes we make is every time we like to use the word or instead of a comma. So you will find a clause that says any dispute or claim or difference or controversy arising out of or relating to. That's not the right way to draft it. So if I replace every comma with or, it's even longer than it needs to be. But if I put commas where I can and I leave or for very specific distinctive factors, then the clause is easy to read. I have done so much in this clause, but I have also used definitions, I've punctuated, and I've been clear enough to say there is no foreseeable controversy that is left out of this clause. So in arbitration, you would then say this clause is not pathological because it tells us which rules we will use, what we will be disagreeing about. Then I come and say there shall be one arbitrator. Because one can look like I write a figure and I use parentheses. According to the ICC rules, I could have said the parties hereby agree. This is what I've seen clauses that look like this, or I used to write clauses that say the parties hereby agree to submit their dispute to a single arbitrator chosen under the ICC rules, saying the same thing, or chosen under whatever. If they disagree, the ICC rules, for those who are familiar with arbitration, specifically say, you nominate, I disagree. I nominate, you disagree. If we can't agree, the court at ICC chooses the arbitrator. That choice is binding. We have saved ourselves repeating all of that by simply writing one sentence. There shall be one arbitrator appointed according to the ICC rules. So if I don't have experience in arbitration and I receive this draft, it behooves me to go and look at the ICC rules before I tell the client, sign. That's what I meant by read every word. Because if you don't know the ICC rules, then you don't know that you have taken away the autonomy of the parties to choose. But why would I agree to this clause? Because where one of the parties does not want to arbitrate, then the choice of arbitrator can be the reason why they take 2 years without agreeing on who to arbitrate. Or they end up before a judge on that question. And then one of the parties raise the PO and say, no, arbitration clause. No, the clause is unenforceable. Justice Weru must write a ruling on this. We have to wait for 2 months. But meanwhile, the commercial sense is stuck. So you can say what a simple, clear sentence means, but also you can see the danger of looking at that sentence without understanding its foundational basis. Now, the seat or legal place of arbitration shall be in Uganda, London, or Mauritius at the lender's election. Again, I think about that and I ask myself, is this fair? And the drafter of this clause has done something that arbitrators would appreciate. The seat or legal place, that is one of the trickiest areas to understand in arbitration. What is the impact of that decision, of that sentence? The impact is that wherever the seat is, that procedural law is going to govern the controversies that arise. So if the seat is London and you want to set aside this arbitration, go to London. You can't set it aside in Uganda unless it is void for public policy. So you can see that one sentence, short, crisp, but it is saying two things. One, there will be procedural aspects that only London courts can deal with. 2, there is an election, Uganda, London, or Mauritius. Now the High Court has held one of the parties to this clause went to a dispute. Dispute is fairly notorious now in the public domain. And one of the parties went to the court and said, no, this was unconscionable. Why? Because it said the lender could choose where to go. And the Ugandan judge said, Justice Wamala said, no, wait a minute. The lender excluded their own country. The lender is from South Africa. So you can see that now a debate on unconscionable bargain, again, what is the law, but also practically speaking, the judge is saying the lender excluded their own country, they couldn't have been unfair. But the argument was, is the lender's election enough? Of course, these are subjective points that we can all debate. But the last paragraph, the language used in arbitration proceedings shall be English, full stop. Short sentence. All documents submitted in connection with these proceedings shall be in the English language, or, if in another language, accompanied by an English translation. Every foreseeable risk that could stall this arbitration is anticipated. Short paragraph, a short clause, 1, 2, 3, 4 subparagraphs, but covers very many technical arbitration rules. The points that I chose to end with this because I was emphasizing, the one thing I would have changed if I had written this clause, and I did not write it, I would have removed the passive voice. So for instance, I wouldn't have said that there shall be one, no, that's not passive voice. I'm looking for passive voice. Instead of shall be, I would have used active voice, because active language changes and makes sentences much clearer. But if you think about this clause, it reinforces where I was coming from. What have the parties agreed to? They're agreeing to a dispute resolution mechanism. Number 2, why are they going to arbitration as opposed to litigation? Because this was a specialized kind of financing, and they feared that the complexities require a mind that is sophisticated enough. Now, obviously, court is the expert of experts, but this is a foreign lender who is saying, I don't know much about Ugandan courts. I understand ICC arbitration because I learned to people from all over the world, all over the continent, and this is the tough I understand. A Ugandan borrower who has sophisticated counsel. In fact, in this dispute, the judge did say that one of the judges did say that the borrower had some of the most sophisticated lawyers in Kampala advising them. There's another dispute. By the way, another common mistake. Choice of law and choice of dispute forum are not the same thing. Please do not treat them as one. Saying that English law will govern the contract is not the same thing as saying a dispute shall be resolved in arbitration. I have seen contracts where those two are fused into one clause. That is a mistake. And I would encourage us to avoid it. The other point, and maybe one last one, another example I wanted to use is, do not write a contract, a clause which you know is going to be impractical in the technical sense of the word, or if you know there is information asymmetry. One good example, in the old production sharing agreements, 98, 2001, 2004, the tax provision was one sentence. It said, all tax matters shall be governed by Ugandan law, full stop. As we all know by now, until 2008, there was no provision in the Income Tax Act on petroleum taxation. What was the result? The oil disputes of 2010 to 2014. If we had come down and said, wait a minute, we need to have fair tax provisions, but we also see in the law, this is the issue. Let's talk about what the risks are around this point. Then would have been transparent, would have been clear on what we are focusing on. I end with a simple principle. As we are drafting contracts, let us build relationships. Let us not kill relationships. I have negotiated contracts where by the time I'm done, I am sure these parties will never do another deal because of the way the negotiation went. And unfortunately, it pains me to say this out loud, but sometimes lawyers are part of the problem. So I would say that it helps to think about, when I litigate let me take an example from human rights litigation. When I litigate human rights cases, Professor Mbazira, and I mention his name to give him credit, taught me a very simple principle. Every human rights case has a human face. There is somebody aggrieved by every human rights violation. Put a face to the dispute, and you can see how that changes. Justice Mubiru just told us that even judges are human. So if you think about, and my Lord, I really appreciate the way that you broke down the ethos, the pathos, and the logos. If you think about that dichotomy, and as a litigator, you walk into a court bearing that in mind, it really does help sometimes just know when to shut up. But please forgive the use of language there. But if you think about a transaction in the same way, would these parties want to do another deal when they are done with this transaction? I have found that to be a useful test. I hope I have said I hope I've been of some use, and I will leave it at that. Thank you very, very much for your kind attention, and thank you for having me. Over to you, Zubeda.
You've shared with us so much. I hope we are all going to live as better drafters of contracts. Let's go back to the basics. Our first year contract law. Let's look at capacity, consideration, and basically also what I took from it is if the guiding principle should be your ability to build relationships and not just to break them just because you've been given the mandate to help parties who are not knowledgeable, very knowledgeable in the law, to help them draft their contracts. I see a lot of love from the virtual audience. They are clapping for you. Councillor Chirunda, well done. Thank you very much. Chan Godfrey Masereka says, very insightful indeed. Caroline M. Marutaro says, did Councillor Chirunda talk about templates? Do you mean templates, contract templates?
Oh, actually, Zubeda, that's a very good reminder. That's a point I forgot to mention. I think the question there, and I had hinted that I would talk about the use of templates. Now, there are two conflicting rules here. Rule number one is never reinvent the wheel. If there's a mortgage deed, there's a mortgage deed. In fact, Ministry of Lands recently, not too long ago, guided and said the mortgage deed should not exceed 4 pages. So if there's a mortgage deed. Now, templates are useful. The mistake we make is copy and paste. I think that is extremely dangerous because I have found in my experience that no two transactions are identical. In the end, there will be that one thing that distinguishes one transaction from the other. And the risk with using a template or a copy and paste is that you just never know when the thing you forgot to adjust becomes what causes you trouble. Of course, if you're looking at the loan master agreement, the loan market association agreements, for instance, if you're doing a syndicated loan, it is likely you are going to end up with 200 pages by the time you are done. Why? The financing agreement is rarely less than 100 pages. The security documents will always be in the multiples, 5, 10 mortgage deeds. If you have charges, you have debentures. These are not documents you can make up, and they will really influence the insurance policy. They will really influence how the deal comes together. Recently, we were advising on a transaction whose value was about $120 million. And the lawyers in London who were advising the lender opened the deal room to us. Client brings you in late. They've been at this for 8 months. They really want to close. They're coming to you at the midnight hour. You don't have the time to start from scratch. The templates will be helpful. If you are going to use templates, these are the tips I found to be useful. Number one, know the subject matter. If you don't understand the template, find someone who does, please. Because there will be clauses that nobody expects you to renegotiate. For example, a cross-default clause. If you walk into a room and you are just a cross-default clause, everyone will just know automatically you don't know what you're talking about. And that is a problem because you're at a disadvantage. So know the template you're working with. Number two, actually read that template. Don't just skim over it, because it may have been written for a different context. Number 3, make sure the template is actually practical enough for your scenario. Because if the template is written for the English market, and here we are saying Ugandan courts have jurisdiction, but it is requiring a clause, a warranty that we know that in Uganda is the Contracts Act has changed the common law position, then please change it. And that is why we read the template. Because, for instance, once we codified contract law, there are some principles of the common law that whose application we restricted in the Ugandan context. So if you simply use the template because Clifford Chance gave it to you, without paying attention to Uganda's Contracts Act, then you're going to have to debate before a judge whether or not that clause is enforceable. And then you go to your clauses at the back, and you have to figure out, okay, to the extent that this contract is, the boilerplate clauses, to the extent that a clause becomes unenforceable, then it is weaved out. Now, if you remove that clause, does the contract exist? I've seen a dispute where if you took out the consideration clause or the recitals, what would happen? But the parties are fighting. Why? Whoever wrote that contract did not look at the other contracts that were related in that transaction to see how they interacted. Another common mistake is you have 10 contracts. The template said arbitration, nobody touched that clause, but the other 7 contracts are saying litigation. The 120 million transaction I talked about earlier had that issue. Now, here you are, coming in 8 months after the negotiation started, and you're saying, ladies and gentlemen, this doesn't make sense. Your security package is saying litigation. Your financing agreement is saying arbitration. How will you arbitrate if you must also litigate? And therein lies the problem with templates. So 1, use them when you can, but 2, read them, every one of them. 3, make sure you actually understand the commercial sense as well as the legal application before you settle on those templates. I hope that was helpful.
Thank you very much. Mr. Paul Kasami says, in service-based industries where standard form contracts are routinely used, the negotiation is often more about commercial leverage than legal drafting. Beyond reviewing clause impact, what is the meaningful role of the lawyer in shaping the contract in a way that reflects the actual commercial relationship rather than simply reinforcing whichever party has the stronger bargaining position?
That is a fantastic question. And I will say maybe 2 or 3 things in response. Number 1, Mr. Kasami, you are right. A lot of this looks like uneven bargaining power, but therein lies the first opportunity. A good lawyer will sit across the other side of the table and realize that just because the party is Airtel and they are big, doesn't mean I can't negotiate. The first mistake I have seen is parties who assume that because the bank is big, they will never agree to what I say. At the end of the day, the reason they are giving you a contract is because they need your business. Press that leverage and go and say, this clause here doesn't make sense. You would be shocked at how many institutions will actually pause and say, okay, fine, we'll make an exception. Of course, and particularly the bankers on the call here, I will have no mercy. The bankers can be stubborn and obstinate. But I have also seen situations where you say to them, and there's a number of reasons why people say, that is a standard clause. I think that a good advisor should never take it at face value on the expression that is a standard clause. Our role as advocates is to go and advocate for the borrower to say, it might be standard to you, it is not standard to me, and the way I see it, it is unfair, we will rewrite this clause. And of course, especially with the smaller clients, the question then is going to be, what if they refuse? Then what you want to think about is, was the deal fair in the first place? Do you want to do that deal? Sometimes the best deal you ever do is the deal you never did. So one way to go about it is press the advantage. Think about a small software company that has developed a business a platform that a bank needs. And the bank really wants to tap into this green area that no one is tapping into. Surely they have leverage and they will renegotiate that clause. But the second thing is that in service-based contracts, ask yourself, where is the actual value and what am I protecting? Because sometimes we are finding that the legal drafting, we are obsessing over everything else and not the actual commercial sense. So which takes us back to joint value creation and joint value maximization. Anybody who sees value on the other side of the table would be unwise to walk away. And I have found that that tilts the leverage significantly. Number 3 is focus on the majors. As long as you're able to get your value safely and you're able to allocate the risk to where it needs to go, then maybe what you can do is you can trade one clause for the other. And you will say, I will concede this clause if you'll adjust this one this way. Or I will adjust the value proposition this way if you'll adjust this clause that way. So you would find that now we have gone from drafting to negotiation. And I have found that every rule, every clause in this world is negotiable.
Thank you very much. Ms. Nansubuga says, thank you so much, Councillor Chirunda. It was a wonderful presentation. Kindly share your presentation with me.
Unfortunately, Ms. Nansubuga, the place where I started was, today I went off the cuff. I do not have a presentation. I don't know if this is being recorded and if the recording will be available, but maybe in future I will think about, I will probably spend some time and put this material on slides. But for today, unfortunately, I don't have a slide deck.
Okay, she continues to say, times have changed. Simple, clear, and practical contracts are the way to go to avoid ambiguity and more disputes. I also believe both parties should meet more as much as possible with their lawyers to rule out untracked issues. Yes, that is a very beautiful contribution. Justice Mubiru has written a lot from from Council's presentation. I don't know if you have anything to say about about his presentation, Your Lordship.
First of all, I would like to thank you, Dr. Chirunda, for the presentation. I came here to share my experience from the bench, but I've turned out to be your student this afternoon. Thank you so much.
My Lord, I am most sincerely humbled.
We'll take your comments about Councillor Chirunda's presentation as well.
Robert, thank you very much. That was a very insightful presentation. Indeed, the breakdown and the simplicity in which you presented it for easy understanding, it was really good. And like we've all agreed, I think we need a practical session for all these discussions. Because when you put up that clause to demonstrate, it made it easier, you know, to understand. When you now start looking at the commas, you start looking at the words, in which place they were put, it came out very clearly. So it's very clear that there is need for a practical class. Thank you.
Yes, thank you very much. I was told, fortunately, when I started working, I had the honor of starting working at the Supreme Court. I apparently was deployed as a legal research officer, but I ended up being an intern, clearly, because, I mean, what can you do for justices of the Supreme Court? And so when you were talking about writing for your grandmother or writing for a 6-year-old, I just remember Justice Tumwesije doing all that, like, it is too complicated, lose the jargon. You're not writing only for lawyers. So I think it is one of the things that all the panelists have reiterated. We should not right to impress. It should be writing to communicate, right to build relationships, and right to avoid disputes. As we come to a close, I would like to thank our panelists, Justice Mubiru, for generously giving yourself and sharing yourself with us. We did not think, when we wanted to get you, I think we were punching above our weight. We were like, okay, let's try to get him. And you were so generous, you accepted to come. And not only did you accept to come today, you have even offered a practical session for which all of you, I'm requiring all of you to come and join us. So I was talking to you and you said they will need clear pleadings so that you go through them and show advocates where the mistakes are and how they can avoid them. Thank you so much. The Uganda Law Society is very, very glad to have you. And I would like to thank our audience. You people have been, you see we have 92 people on call, and you've been here since 9 o'clock. Thank you so much. Our theme was Master Commercial Drafting Before It Masters You. And I hope it was a point of self-reflection, kind of like punching holes in what you think you knew. Because some of us feel like, yeah, because I've done 8 years or 10 years, I think I'm good enough. But it is always a good thing to check yourself. It's a bold challenge and a gentle reminder that learning never stops. And drafting is not about writing perfect English. It's about foresight, seeing the storms before it breaks, seeing the storms before they break. And if we can apply all the lessons that have been shared by our speakers today, I think we will be able to deliver access to justice and also lift our craft. I thank you so much, and I would like to invite Ms. Doreen to speak on behalf of the Uganda Law Society. Thank you.
What an honor. What an honor. Thank you so very much. My name is Doreen Atkunda. I am humbled to serve as the head professional development and members affairs head here at the Uganda Law Society, and it's with profound honor to be here before you this afternoon on behalf of the CEO, Uganda Law Society, Ms. Christina Ward, who has generously delegated me to convey her vote of thanks. Allow me to begin by expressing our deepest gratitude to Honorable Justice Stephen Mubiru. Thank you so much for consistently and generously sharing your vast knowledge and wisdom with our members of the Uganda Law Society, and continue to inspire all of us. My Lord, your unwavering commitment to mentor and professionally grow within the legal fraternity is truly admirable. We hold you in the highest esteem, and we pray that your spirit of service continues to illuminate our path. A sincere thank you as well to Ms. Olivia Charimpa Matovu. Your generosity of spirit and wealth of experience you so willingly share with us whenever called upon. Your consistent support strengthens our collective pursuit for excellence. Thank you. Also, a heartfelt appreciation goes to Mr. Robert Chirunda, who, despite being out of the country, took time out of his demanding schedule to contribute towards this session. Your dedication and willingness to guide and enrich the profession from afar is deeply appreciated. We don't take this sacrifice for granted. We're equally grateful to Ms. Zubeda here, the most perpendicular, from the Muslim Arbitration and Mediation Center, for your partnership and outstanding coordination in making this second edition of the Legal Writing Masterclass a success. Collaborations like this remind us of the power of unity and shared vision in advancing our profession. And finally, to our members, we thank you for attending in such impressive numbers. Your participation and enthusiasm are like the lifebone of our programs. As always, we remain committed to serving you diligently and ensuring that your professional development needs are fully met. Please remember to continuously engage in these trainings as we look forward, as we come close to the end of the year, and make sure that you accumulate your minimum 20 CLE points before the end of the year. And in fact, next week we have a 2-day training on finance and banking. It will be 10 CLE points, and it will just be 200,000 Uganda shillings for our members, and our young lawyers 140,000. And we look forward to seeing you, for those who have accumulated the points, so that you can do so. So allow me to take this opportunity to thank you, and we continue to grow together in excellence, integrity, and service. Thank you so much. Have a great afternoon.
Thank you, and have a great afternoon to you all.